Thank you, Mr. Program Director, for your gracious sentiments. Much appreciated. Program Director, my esteemed colleagues in their absence, our distinguished guests of honor. I see one in attendance already, who for now will remain nameless. Ladies and gentlemen, Molweni, good afternoon to you all. I'm not too sure whether I'm audible. I hope so. As you have heard from the program director, I've been assigned the duty of welcoming you to this event. I've been wondering why I was requested to welcome you to what the hosts, the Mthatha legal practitioners, have dubbed the Meet and Greet annual event. And whilst pondering this issue in bewilderment, it finally dawned on me that perhaps my age has something to do about this. I concluded that in the event I waffle in welcoming you, everyone gathered here would find it easy to forgive me for staying in what was not the task assigned to me, because they would most likely attribute my veering off the mark to senility. During my time as a judge of the Eastern Cape Division, I had the privilege of presiding in motion court. And on those occasions, there were applications for admission either as advocates or as attorneys. And whenever there were applicants desiring admission, I would, in wishing those whose papers were in order, without fail inform them of what was expected of them as officers of the court and esteemed members of an honorable profession, which is that they should always scrupulously uphold the ethical standards of the profession. Many years ago, I stumbled upon an article by someone who attempted to provide a definition of an attorney, which I must confess I found to be demeaning and offensive. He described an attorney, open quotes, as someone who would do whatever it takes to rescue your estate from your enemies and thereafter keep it for himself. Close quote. But I think the true answer to this question is to be found in what the late Justice R.P.B. Davis said in his foreword to the first edition of Hepstein and Van Vincent more than 7 decades ago. He posed the question, and I quote, "What is the nature of this honorable profession to which we all belong? Bench, bar, sidebar alike." He proceeded to answer this question thus, and I quote, "First and foremost, it is a profession, not a trade or business. officers of the court are as much a part of the court in which they practice as the judges who preside over them. It is an honorable profession, one to which it is an honor to belong. He continued to make the following statement, and I quote, "It is permissible to wonder whether this fundamental truth that we all belong to an honorable profession is always realized today as fully as it was in the past. If it is not, I feel that fault may lie in part, at least, with our system of education. Too much stress seems nowadays often to be laid on pure utilitarianism. The first question asked about any subject in the syllabus is whether it will help the student to make a living, not in the sense of whether it will fit him to be a better member of society and society in the particular walk of life which he is choosing, but simply whether it will enable him to earn more money. And an outlook of that kind, besides showing an entirely wrong sense of values, is bound to obscure the fact that a student should not enter the legal profession as a money-making concern. If the making of money is the chief aim in life, then let him enter some branch of commerce. He will make far more in that way, and though no doubt he will still be bound by the dictates of honesty, he will not be hampered by the same strict rules of conduct in his quest for monetary gain as he will in the legal profession. That profession is one by which to acquire honor and not fortune." Close quote. I would urge your members to spare a few minutes and read the Justice Davis foreword. There is much to be gained in doing so. I am more than delighted that you saw fit to invite initially 3 eminent gentlemen of law to come and address you in different ways. They all have made their mark in the practice of the law. I know that they will not openly admit it because they are modest men who are not wont to blow their own trumpet. I'm certain that in their interaction with you this afternoon, they will share with you their own experience as to how they rose up the ladder from being the rankest of juniors and to become who they are today. They will tell you, I would imagine, that nothing is impossible to a willing and determined heart. And they will also tell you that nothing happens by itself. One has to understand that you have to make it come your own way by exacting yourself. I once heard someone say, and I quote, "Hold yourself responsible for a higher standard than anybody else expects of you and never excuse yourself." Close quote. I'm pleased as I gaze through this venue with the huge turnout at this meet and greet event. That you will be intellectually enriched at the end of the day is beyond question. Whoever conceived the idea of you getting here today must be commended. I wish you a fruitful and beneficial interaction with your guests of honor. And reverting to what I was asked to do, I heartily welcome you to this important event. Thank you.
Ladies and gentlemen, please give a warm round of applause to Yes, we are really indeed honored to have you, Justice, in our midst, and we do not take it lightly. And can we also just give a round of applause to the organizers of this event, of this auspicious event. You are going to be giving a round of applause here and you won't play, so please make sure that your hands are ready. Another round of applause to you, beautiful people. Oh, I can't distinguish between a CA, a PA, a director, and all of that, but that's the purpose of this event. And I can see there are a lot of people that are here that are very prominent in the legal profession, and for those that are seeking admission, there's going to be a speaker that I am going to be calling here. You better make sure that when he comes here, you smile so that when he gets your papers. Yeah, but good people, we are going to have a good time and a lovely time. Now, without further ado, we are going to call upon Mrs. Gaza, no Miss Sichange, to come here. Can you open his hand, please? Come on, guys, you can do better than that.
Good afternoon. I greet you all, respectfully, our guests and our esteemed colleagues, the judges, the SCs that are in our midst. Thank you very much for being with us. I am called upon to speak on the purpose of the day. This event, the purpose of this event is simple and yet very critical. We are here to deepen and strengthen our relationships and the unity amongst ourselves within the legal fraternity, and also to create relationships with our sponsors and service providers that have done us the honor of being in our midst. So we encourage each and every one of you as we learn and facilitators that will be speaking here today to create the relationships that you so much need now or will need in the future. We encourage you to reach out to a person and reach out to a senior so that you are able to foster relationships that will teach you and will help you in the relationships that are necessary so much in this fraternity. I believe that each and every one of us will have something to take away at the end of this event, and I would very much like to thank each and every one of you that made this possible. So make very good use of it, and I hope that you very much enjoy yourself.
Thank you very much, colleagues. Mbixane, Mrs. Gaba. Zaba. Please. But my name is Chulekazi Sichange. I am a PA up in Tata. Mine is very short. It's just to name a few distinguished guests that we have in the midst of us. We have Advocate Toby SC. He is in our midst. We have Advocate Mbofu SC in our midst. We have Justice Pete in our midst. We have Mr. Nokiesi AJ in our midst. We also have Mr. Sidaki, pardon me, Mr. Tolo. From legal practice, we have Mr. Horner in our midst. From Sanlam, we have Mr. Eitingo. And also we have our directors up in Tata. We have our advocates from Tata, East London. We have junior legal practitioners. We have candidate legal practitioners. We thank you very much for you being here. Thank you.
Thank you so much. Can you please give them a round of applause? Ingathi yasokolisa lento ka Mrs. nguMiss Jiba. Eka Mrs. sabuya siyibone. Sabuya siyibone. Ulibele one thing Miss Sichange kwi juniors and SCAs. I'm a proud SCA. I'm a proud senior candidate attorney. Siyacela recognize. Sinegalelo in the profession. Yeah, sinegalelo in the profession. Bezikhathazekile illegal practitioners izolo. Ke kwaphuma article. Kule article there was one thing that was missing. It was the name of the hospitals. But the hospitals were not told. They can illegal practitioners. They try. There's wrong, but good people, we are all here, and we thank God that we are all alive. Now we are moving on. There are people that have helped us and they've made a huge role for us to be here. And we welcome them and would love for them to come and put a word or two. Can you please welcome Kupukani Wealth Liberty, Mr. Sitaki. I think I pronounced it correctly. Kana simkhwabeleni izandla Mr. Sitaki. Sizozikhwaba izandla till ade azofika apha. Masiphinde.
Thank you so much, Miss.
Good evening. My special greeting program director, highly esteemed guests, Advocate SC Ngogaitobi, Advocate SC Dalimbofu, Justice Pete, and AJ Mr. Nokiesi. I also want to extend my greetings to all the senior and junior legal practitioners here, senior and junior advocates that are amongst us. I also want to extend my greetings to all the non-legal professionals, citizens that are with us today. Ladies and gentlemen, I also want to, I humble myself before the event organizing committee for inviting us to partner with them in hosting this beautiful event. My name is Mfundis Amos Sisaki. I am a wealth planner, a qualified, competent, compliant wealth planner. I'm a curator bonus. I am a trustee, I think for now, as of this is irrelevant for now. I am a director at Kupugani Wealth. Kupugani Wealth is an entity or a franchise of Liberty Standard Bank Group. Today, okay, Kupugani Wealth is an entity that manages just above 500 million AUM, that is assets under management, and I must say is proudly owned by a black South African. And it's proudly owned here in Mthatha. Yeah, with me I have my colleagues, Usi Yambama, who is the financial planner, Vuyo Matzozoma. Vuyo Matzozoma is also a financial planner. Lona Mkechwa, the business administrator. Wendy Rigni, a financial planner. Zizi Ponzamela, a financial planner. Sivu Ntlati, a financial planner. And Pumla Ngozi, also a financial planner. All these guys that are here, these people are the face of Kupugani Wealth. We are entrusted by Liberty Group to ensure that Liberty footprint is everywhere, especially in the former Transkei. Ladies and gentlemen, I always find it difficult to speak to attorneys because wealth planning revolves a lot in the law or legislation. So as a financial planner, when you speak, you talk about law all the time. Okay, nevertheless, I think today there is nothing more important other than we asking a question that is, why wealth planning matters to legal practitioners? That's the question of it. Why wealth planning matters to legal professionals? The answer to that is that legal professionals spend their careers protecting rights of other people, estates of other people, wealth of other people. But however, the fundamental question is that, do you guys have time to look after your own estates? Do you have time to sit down and draft your own will? Do you have time to sit down and analyze your wealth in terms of is it viable or not viable? So that's what I want us today focus on. Focusing in the few pillars, that is risk management, wealth structuring, and intergenerational wealth. In my experience, I've consulted and I've got lots of clients who are attorneys. I think I can safely say you guys are lacking a lot on this field. Yes. As a wealth planner, I've experienced that most attorneys, they enter in this profession with different objectives. And in these objectives, I think the speaker before me, Judge Betze, spoke about money-making thing. It is a good thing, but wealth protection revolves about protecting wealth. First, protect what you have. Before even of thinking, creating what you don't have. It revolves around those two things. Of course, wealth planning is quite a vast tool that you can think of. But to those, especially those young attorneys that are within us today, I want us to discuss or to give a brief. There are three pillars to protect your wealth. One is risk protection, personal personal risk protection. Number 2, wealth protection, creation, and liquidity. You, the attorneys, when I talk of liquidity, you do it almost every day. In your estates, first thing you think of when you see an estate is there liquidity in the estate. It's a question of a yes or no. If there's no liquidity, it's clear that estate will delay longer. So you experience these things, but the question is, is there liquidity in your estate? Estate tax and tax efficiency. Those are key things or key tools that are important for an individual, especially a legal practitioner. So the solution to this, it's a risk protection cover. It's one of them, because I think most of us here, we have seen young attorneys. Some of them pass away, but the question, was that person insured? How about the children of that person? Some of you, they have kids that are schooling in expensive school, but do you have a personal protection cover to make sure that in the event that you're no longer there, your child will continue schooling in that school? So disability, all of you guys are thriving, but is there a disability cover to make sure that in the event that if something happens to you, you are able to continue working, or you are able to employ someone to do your work? Severe illness and income protection. So some people, they good at insuring the car, insuring the house and all those things, but your primary asset, which is your income, it's a question, is it insured? Because without that income, you won't have anything. So hence, one of the primary tools that is important for personal wealth planning is to cover your income first, so that when you can no longer work, you are able to employ, while you're sitting at home, you're getting your income because your income was insured. So you're able to employ someone to do what you are supposed to do. So that's important. And also, this risk cover also talks more on estate planning, estate cover. It is important to have an estate cover. Like I said in the beginning, that you guys deal more with the estate and all these things. So I always expect that when I'm seeing a consulting an attorney, these things they will understand. But estate cover, it is very important because it what ensures in the event that you're no longer there, the families inherit assets instead of inherit liabilities. And you know that you do this, you have seen it. In terms of the legislation, this is what I'm afraid of. When I talk, I will have to say legislation, but the legislation, it gives powers the executor to sell any and every possible properties in the estate to make sure that the creditors are paid. But do we do it for our own personal capacity, or it's okay just for these clients? So these are things that are important for us to discuss, Jembebe Chilo, that this conversation, it's a continuous conversation, because if you sit down with the wealth planner and plan accordingly, you will make sure that, okay, your children as future, it's sorted in your estate, because your Nkindo revolves around your estate. The protection of your heirs, it's sorted. Efficient estate winding up, it's done, because there's a financial or wealth planner beside you. Preservation of family properties. You can also make use of usufruct. Those are things that are available for use as an attorney, because you guys work hard every day. But the question is, in the event that you're no longer there, how is your family going to live or survive? Are they going to live, or are they going to survive? So it is important to have that forward thinking now. And I also want to highlight the investment philosophy. most attorneys, they're good at investing, and they consider investment as the primary tool, which is not the primary tool. Like I said before, the primary tool, it's a risk planning. Even on investments, there is asset-based thinking and liability-based thinking. Some, they invest for the benefit of having more liquidity in the investment. Some, they invest on personal capacity. Some, they invest on business capacity. But sitting down with the wealth planner, it is important because you will understand the benefits of investing in the business, the benefits of investing in your personal capacity. And these benefits revolves around SARS. Most attorneys have experienced or have heard that most attorneys, they have a problem with SARS, you know. And I remember once, I think I was talking to Mr. Makangela, it was 2018, 2019, and we had an event in Joburg. I said, Mr. Makangela, we had an event in Joburg with SARS, and there's something big coming. So this thing of especially black attorneys and SARS is going to come very badly, you know. And I'm really not surprised that it had arrived, because I had knew it far before. So it is important to understand that though you own the business, but at the end of the day, the business has employed you. The business supposedly to give you monthly income. I know some of us here, because you're the director, you just swipe as and when you wish, using the business card for personal things, understand, and do whatever you wish, pay school fees on the business card and all that. You know, all those things. I'm not blaming you. It's lack of exposure on the SARS or tax perspective, and which also play a role, because we're supposed to have gatherings like this where we educate each other and expose each other on these things, because SARS is very dangerous. SARS is very, very dangerous. So it is important to sit down and look at what is it that I can pay on a business capacity, but most important thing, you must get a salary from your own law firm, from your own business. There are so many ways not to avoid, but to minimize tax. So many ways. I'm still finding it difficult, because you guys, you have accountants that are supposed to expose you on strategies in managing tax. But maybe we need to have an accountant within us and tell us why it is like that. Because my understanding is, if you are my attorney and I get into troubles, at least you should take a little pay. Do you understand? So why are you getting into these troubles, but there's an accountant? As a financial planner, we have a responsibility to make sure that in all things that I've noted above, you are covered, you are sorted. In terms of the will, in terms of everything, that you are sorted. When you're no longer there, I'm able to face your family with confidence. I'm able to sit down, read your will in confidence. Talking about the will, you guys do lots of wills, but the very few of you that have wills. So that's why I said it's really difficult to talk to attorneys, because you talk to people that understand these things, and they know these things better. So one of the objectives of this is that let's take a step back, as and when, at least give yourself once a year, sit down with your wealth planner, do a review in terms of structuring your investments. Because now there's US-Iran war, to understand how is your investment doing, how is it performing? There's high volatility in the market. How is your investment doing? So you're supposed to sit down with your wealth planner and tell you that things aren't going well. Let's move from offshore investments and local investments, so for a better performance, and wait for some time. So portfolio balancing, it is important that you do that on annual basis, and also doing a risk assessment, because the fact that you had a risk cover 10 years ago, it might be irrelevant now because of growth, personal growth, and estate. I met with this client. He says, I have a 20 million life cover. I'm sorted. And good people, having a lot of life cover or risk cover, it can also disadvantage you. Because I remember the abatement in South Africa, you know the attorneys, the abatement is only 3.5 million. And anything beyond that is subject to tax. So remember your beneficiaries. The sad thing is that you'd have a 20 million life cover, you have 2 kids, and you say this one gets 10 million and this one gets 10 million. But SARS said my abatement for that person on that 20 million is only 3.5. So thinking that you have left your beneficiaries with a lot of money, it's not like that. Those children never worked for that money. SARS want their share. So those beneficiaries have to work, have to pay a portion to SARS on the money that you have left with them. Hence, it is important that we discuss these things. More than discussing them, you know and understand the implications of having these things. Because having too much life cover can, like I said, it can also disadvantage you because it increases your estate as well. But the key thing that I expect each and every attorneys, especially in the former Transkei, in the Eastern Cape Black attorneys, is to address the issue of estate, liquidity in your estate. Is one of the biggest issues that I always come across. Number 2, like I said in the beginning, I'm a trustee. In the trust that I'm a trustee on, I've realized that sitting with the attorneys as trustees in the trust, there is a huge misunderstanding in terms of what is supposed to be done in terms of fiduciary duty. You found out as an attorney, especially young attorneys, when you are appointed to be a trustee, it's a good thing, but just know that to these 2 things, the fiduciary duty involved there. Number 2, the compliance involved with being a trustee, because being a trustee of that trust, you are the administrator of that trust. Being an administrator of that trust, you are fully responsible for SARS. If that trust owns SARS, owes SARS, maybe 2 million or something, SARS won't write to the trust, will write to the trustees. That's the last biggest thing, being a trustee, especially if you do not understand these things. I've recently been appointed to another quite huge family trust, and the attorney has resigned. I was told that he has resigned. But the trust, after I've done my analysis, it was owing 3 million plus. He resigned 2019, and they've been operating. And I said, I don't understand, because you're an attorney, you're supposed to know this. How are you operating? Because there were 2 of you, and the trust at least you're supposed to be 3. So why were you operating? So that's such things. It's important that I understand that you guys are experts on this, but it's important also to apply it as well. So now the trust is owing a lot of money, and when I'm telling these guys that I can only accept the nomination when the trust SARS says everything is well. But that attorney that has resigned, he resigned. But there was no, there are 2 minors there. And those minors, they don't know that. and they were not represented, those minors. So the Trust Property Act was not followed by that a particular attorney. Unfortunately, it's in Cape Town, was not followed, and unfortunately, he will have to make sure that he comes. I told them that he must come back and be responsible for that. So, while you are appointed and nominated for these trustees, it's important that you understand these things, and because SARS is just another thing that is very dangerous. SARS is very dangerous, especially if you overlook SARS. Another thing that we should sit down probably for a day and discuss it alone is the issue of succession planning within the legal practitioners. Legal practitioners, you guys make a brand in terms of name, but in event that you're no longer there, either death or age or something, but it just goes down. Imagine in the next, even if Mr. Nokesi, if you're speaking of Mr. Nokesi, it has become a brand, not just the name, So, but if the question is, if something happens to him, is there any proper succession planning in place? So those are things that you should plan for them now. You should plan for them now. Succession planning, it's very important. My lecturer, when I was doing my junior diploma in wealth management, invited a firm in East London that was, I think it's early 90s, but is still practicing today. So we as black people, it's not impossible that we cannot do that. It is highly possible that even if you're no longer there, 100 years after your death, but your practice, it must be working. That is very important, succession planning. Because if you do not have a proper succession planning, you will experience a lot of problems, and you're putting your family in a huge debt. And all what we have worked for, it just goes to the drain. So succession planning, it's a very critical a tool that maybe one day we should just sit down and discuss it and make sure that you guys are aligned with when it comes to that. And I will talk about tax in a trust. Most attorneys, they have personal trust, which is good. But you realize in these family trusts that the way that they are structured, it's not for sustainability, it's not for succession planning, it's not for the benefit of the heirs, but it's more on asset protection or property protection. It is one of the benefits of having a trust. Also, I think it was around 2022, I'm consulting an attorney. He says, I have a property that generates 250,000 a month. And I was quite happy because, okay, he's a colored guy. I said, oh, wow. He said, it's owned by a trust. And my immediate question was, where is your accountant? Because you have a property that generates 250,000 a month. The accountant already should have notified you about tax implications of that. Already. It's okay to generate it, but what about the tax implications? He said, no, he's there and all that. I said, okay, because I was not consulting for that. We're consulting something different. I was very worried. Last year, November, he said, sir, I'm owing 9 million plus. I'm told by SARS that my trust is owing 9 million plus. Unfortunately, I could not at that particular time tell him the honest truth about the percentage of a tax in an income that is owned by a trust. But I just said, look, he must sit down with the accountant and try to revise those things. It's not only one property, a lot of properties. So that's where you'll understand these things better if you sit down with a well planner, because it's good to have a trust because your assets are protected, but it does not end there. Which assets must you put them on the trust? Which assets must you not put them on the trust? Why? Because it revolves around what are the objectives of you putting that property or that asset in the trust. It revolves around that. There is a, I normally say to business people, we as black people, you found out I have a company, Kupugano Wealth. I have another company, so I've registered 3 companies under my name. And all of these companies are exposed to SARS, all of them, which is a risk. However, there are strategies as an attorney or any business person that you can use to make sure that you minimize risk exposure, you minimize tax, and you minimize creditors as much as you can. Because you can have a trust, but the trust can own a company, a holding company. A holding company can have subsidiaries. With just all that, it's taxed under one company, which is that holding company. Hence, you found out Liberty, Standard Bank Group owns Liberty. So Liberty is taxed under the same tax of Standard Bank. Standard Bank Properties is the same tax. There is no tax different from Liberty. It's taxed under Standard Bank Group. Standard Bank loans and all these division subsidiaries are taxed here, which makes it easier that if Liberty didn't do well or they made a loss, it separates from the major or the holding company. So this thing of having companies and all those things, it personally, and in our experience, I mean, it works against you of registering a lot of companies. But a holding company, it gives you an opportunity to try to manage and minimize tax as much as you can. Well, of course, there are a lot of strategies of minimizing tax. You cannot avoid it. Let me say, you cannot avoid it, but you can minimize it as much as you can, you know, based on the strategies. But those strategies must be in line with the legislation. So those are important tools that I wish and want all of you guys take into consideration. And before you can even think of, remember SARS. SARS does not have a contract with your accountant. You just give a consent to your accountant. But when you owe money, SARS doesn't go to your accountant. They go straight to you. And unfortunately, SARS, you don't have to sign any contract with SARS. So immediately there's money coming into your account. SARS, they know, okay, there is our client. Do you understand? So in making sure that you run efficient law firms, efficient companies, please consider this SARS thing. Sit down with the world planner, sit down with your accountant, especially if you sit down with your world planner and accountant and try, because they speak the same language, but it's with different expertise. So it's important that you do that. Our role as Kupugano Wealth is to make sure that we provide personal and business solutions, investment solutions, retirement planning. While I'm talking about retirement, attorneys, they normally say they don't retire. Yeah. So, however, it is important, ladies and gentlemen, to consider these retirement planning things. And to those that belong to Pension Fund Act. I'm happy the fact that Judge Pett said these things, they're on TV now, and there's misconception. People, they think Matrimonial Property Act is the same as Pension Fund Act, and generally, okay, I'm a judge. I've got 5 kids. In the event that something happens to me, all my pension goes to my family, and it is not like that. So, because the Pension Fund Act is legislated differently, where the trustees of that fund, they can decide. If I make an example, my apologies for making an example now, Judge Petse. Yeah, if Judge Petse has 7 million in his pension fund, and the family knows Daddy has 7 million in the fund, and he's comfortable, and directly or indirectly, Mr. Petse is giving someone some money, and that person is financially dependent to Judge Petse. Do you know that the trustees of the Pension Fund Act may have a right not to give your wife the benefits and your children if they don't provide proof that they are financially dependent on you, while that 7 million belongs to you? It is like that. It is like that. Yes, you can put your beneficiaries in terms of the pension on your pensions. It makes it easier for the trustees of the Pension Fund Act, that they don't have to look a person, do you understand? But they just know, okay, we are dealing with so and so. But however, it is easily challengeable. So there are cases that we have seen on TV with regards to that. So it's one thing, especially if you belong to a Pension Fund Act, that you make sure that you align your will, you align your estate specifically with that. So we also offer solution to that as well. Trust-linked financial and wealth planning and ongoing professional reviews. We have partnered with these guys solely to not necessarily to sell, but also to educate, expose, and inform our brothers and sisters like yourselves with regards to this wealth planning thing, especially when it comes to estate planning and tax. I hope organizing team, it's not the last event, and we will continue sponsoring the event and educating, informing, and exposing our brothers and sisters so that they are in line with what we do. Understand, you guys, legal professionals, they understand the law and justice, but we as wealth planners, we make sure that your life's work benefits your family, not creditors, not SARS, not poor planning. That's what we do, and we do best. With me, okay. Number 2, we humbly request that as financial planners and wealth planners, we humbly request that you guys are dealing with rough clients on a daily basis. And most attorneys around in Mthatha, they refer their clients to us for advising in terms of investments, advising them in terms of how to manage money. And since we have started, we are doing so well because there is a brotherly and sisterhood relationship. These are black people. Imagine when someone that has never earned 5,000 rand, you're giving that person a 3 million. How is he or she going to manage that money? And later you meet that person on the street, is requesting 100 rand. So hence we are humbly requesting that you will get our contacts, we'll share your contacts, that you refer those clients to us. With me, I have a lady that we have helped, and I've asked her just to have a 1 minute to tell you how have we helped her. and how is she doing. But before we go there, in last year, there was an email that I sent to a lot of attorneys. An email that I sent to a lot of attorneys. In the office, I received a call, and this guy says, look, hey, I need to see you, I'm in the office. He said, no, I'm not around, I'm in East London. And this guy says, no, I just wanted to come say thank you. Okay, who are you? He told me, I didn't know him. And this guy says, no, in 2019, wafike ekhaya, sinenlwe one, sibhekele isibhedi, and I was still lost. Did yeah? He said, wasokhela indlu no 8 corner. Sakwazi ukuqhubeleka esikolweni nesister yami. Ubrother wami yena lo wayifumene imali yengozi usabambile pha kwi drugs. He put iwayibeka ngolo hlobo. Usabambe pha kwi drugs. Sithi yes. Yeah, because I'm busy. Said okay, yeah, ndikakunceda njani? What no benzokuxelela ba ngala mali ya brother wami. Today I'm a medical doctor. And my sister is doing medicine also. Next year we uyaphuma wenza unyaka wakhe wokugqibela ngoku. Uphumile kulo nyaka. Do you understand? So, but what is unbelievable, the money of that particular client is protected. They were just living with interest on monthly basis. We managed to build a umzi for bona while the capital was protected and a portion of money was flexible. So 6 years later, that money produces 2 doctors. You know, so I want to say, when you're sitting with these, you're sitting with one client doing rough, but you don't know how many people we are helping with that client, because in reality, I once also wrote to Aaron, not Aaron man, but Letswalo, saying that in my experience here where we are living, this rough money, it takes a lot of children to school. This year I've released more than 2 million rand in January just for fees. All my clients, like I said in the beginning, I'm sitting with a book of more than 400 million only on investments. So that this money, don't take it lightly, the fact that you're assisting only this one client, but you're assisting the community. We are putting food on the table in the families, and you are sending school for that family. I'll ask the ladies Zoto Momlula just to have 1 minute and tell us how we have helped him. Thank you. You can come, Zodidi.
Molweni ninjani? Siyaphila khonto. Ndibulisa ke otata abandiqhela ukubabona eTV. Ngokushiyana kwezihlalo zabo. Amen. Igama lami ndinguZodumo, ndingwakwamdludla eLsikisiki. Kwindawo yaseQawukeni, ilali esiphezeni. Ndizothetha nje kancinci, ndinentloni zokuthetha phambi kwabantu. Iwesi abahle kangaka, nibahle guys. Yho. Ndidibene no Mr. Lento nigqiba uyibiza le fani yakhe andiyihoyanga mna. Mna ndithi kuye xa sendingxamile ndithi mfundiso. Ndibene naye ngo-2021, ndidityanisiwe ke ngumntu endandidityaniswe naye for ukundinceda kwinto okanye kwimali endandiyifumene for uba ndanditshowukhwe ngumbane. In fact sasibaninzi, omnye wasweleka, but ke ndasinda ke nam ndingumntu owayephantse wasweleka, kodwa ndasinda. umuntu andisindisayo ke kuba kuye kuthiwe xa kubhujiwe abantu xa befika bezovela kujongwe uba ukhona unonceba nobelila ehlele egumbini abone uba kusokhutsha unonceba uzawuphuma imali atsho ahleke. Ndahlekiswa ke mna ngutata uZibhembe. Ukundihlekisa kwakhe kukuba eze andi-advise about ukugcina imali, about ukubeka isonka etafileni, nento yoba ekhaya sasiphila singabantu nathi sasiphila sihlupheka, ndandingenabazali ke. Ekhaya kulapho sasikhongozela khona indlu, sikhongoza amanzi endlini eyi-1 silala siba yi-8 endlini. Kodwa ke ngokufika kwakhe ukwazile ukufika enze umohluko. Kodwa ke khange kube lula ngoba xa besihlala etafileni hey uyakwata ubhuti. Ndikwate nam ndithi no kaloku mfowethu ligama lam elibhalwe apha kule file yakho utheni ngokuzondenza kanje. Athi yesisi andidlale kanjalo wawusayinile wagqiba masenze ngolu hlobo njengoba sasenzile but ndiyambulela ngoba if wengazange aqine inqinisa inhloko through umsebenzi wakhe nokuhoya abantu ngendlela yoba imali mabayiphathe kanjani ndakwazi ukuyiphatha imali. Umzekelo ngoku ndi-owner ye-flats through Mrs. Bhembe, ndinomzi through yena, kwam kuvulwa nge-remote. Can imagine ke xa kuzovulwa nge-remote benilala endlini yengca nikhongozela ngezikotile xa kunethi imvula. But ke into endiyithanda ngayo kukuba nokuba ngaba bendimane ndikwata kodwa undikwatele kwagqibela yena, but ngoku xa sele mna ngoku ndimane kungena isithi nkqonkqo andizutsho ukuba yintoni litshoyo ifowuni ndithi ti ithi ti ndithi hayi ndiyabulela bethuna. Ngoku abantwana bam ndinomntana owenza unyaka wesine wenza i-B.Ed. Ngexesha wawufika tatam wawufika ebhase grade 12 ndingazi uba ndizomthini uzokwenza kanjani, but ngoku nam ndizoba nomntana ozoba mhle njengani bethuna. Enkosi ndiyabulela kakhulu.
Well, Enkosi Mdludla, Enkosi ezodumo, Enkosi kakhulu. Now this is an example. Mhlambe uyibeka as i-flat bencimba uzawuthi owner is-student accommodation so you can understand the income that she's making. Do you understand? Yeah, she owns a student accommodation. Do you understand? I think i-fight esabanayo uthufuna imoto ndithi wakwaba nayo imoto ngaphambili hayi uyakwazi uqhuba imoto hayi I'm very strict, they know. Did okay, let's finish lento yezi-flats. La income uzayifumana pha ayizuba kwa less than 50,000 uzayithenga imoto not ngalena imali. Hey salwa. But I could not back down. But today is driving SUV yakhe akacela imali. But most importantly, most of her money as the capital awayifumene is still safe and secured, you know. So that's what we do, and we try to do best, and we humbly request that you guys continue supporting us in this client, and we have no choice but to continue doing what you are doing best. And I'll leave you guys with the note from a former Coca-Cola CEO, which said, life is like juggling a few balls in the air. You name them family, you name them friends, religion, and work. But you realize that the ball named friends, if it bounces back, it comes back again. The ball named religion, it bounces back, it comes back again. But you realize that the ball named family, if it goes down, it breaks because it's made of a glass. I wish you all of guys the best, and of course in your personal capacity and your businesses, nikona ningekho be successful. I thank you.
give him a round of applause for the last time. Yeah, thank you so much, Mr. Sitaki. We have learned that there's a lot of I Blew It episodes seated here. We only think I Blew It is for our clients, but I means in Alapendlini. So telling you that one day uzawuza for a full day uzosifundisa ke ngoku kulela yethu imali ncinci sinayo ba ezi 20 rand senza njani wealth ngazo, because they are with millions. But ndiyabona uba thina nezi 20 rand ingathi asikho accommodated. Yes, now we are moving on, and with due respect, I know this is the most hardest part about the program, where you have to ask your speakers to keep to time. I'm humbly apologizing that I have to make this remark, but we'll ask that we keep our speeches to 10 to 15 minutes, 20 minutes max. I've been asked by the organizers, please don't shoot me. Thank you. Now we are moving on, and we are going to welcome Justice Notyesi AJ to come up front. Can you please give him a round of applause? And please give a round of applause to the pamphlet that is carrying.
Thank you, Program Director, Spencer, Advocate Mpofu SC, Professor Ngugaitobi, colleagues, friends, the organizers. I've been asked to talk at least on Rule 6 of the Uniform Rules, as well as to make a reflection in respect of the judgment in the matter of Mzwandile Popokyana, an attorney from the Queenstown area. So I propose to first deal with the issue of Rule 6. This one should not be a controversial discussion, but I want to introduce some controversy around it. In the last 2 weeks, that is that Tuesday and this last Tuesday, we had on the roll, on the first week, 200 matters in the motion court. This week, Tuesday, there were 276. Some of you will recall that on the first week, the motion court had to run over 3 days, and it had to run until, as I'm told, until past 12 midnight, where people were still in court. One has to look what are the real reasons that lead to that. First, we observe 3 things: that the court is pegged with matters that ought not to have been placed in court. About 60% of these matters were in that role for postponement. And this comes about in 2 ways. When a matter is before court, practitioners simply ask for the judge to postpone the matter to the next date. They don't even check whether that particular date had enough space to add other matters. They are simply enrolled. So when you come to court on that day, you find out that there are about 80 matters that are in that court, not for any substantive order that is being sought. That has to do with the manner in which these matters are sent down and the roll is controlled. With that, I must revert. Rule 6 actually governs the motion proceedings, applications, and it prescribes how an application should be set out, how the applications should be set down. Essentially, you have there, almost I can say about 3 or 4 kinds of application. First, you have ordinary applications. Ordinary application is an application where you launch the application in the long form. The rule prescribes how you go about in doing so, and also how you set down that application. There should be no problem about that one, because it will tell you that you serve the interested parties, you arrange a date with the registrar for the hearing of that particular application. Then you have the second category of this application, which perhaps I would refer to the incidental applications. That is, those applications that are related to the main application, Rule 611, that application. Those are the applications that often give problems because it arises from this main application. These are sort of an application to compel the discovery of documents, applications for appointment of curators, various kind of applications that are brought under that rule. What the practitioners simply do with these applications, they do not arrange with the registrar about these applications. Somebody will simply prepare papers, go to court, or upload this application for the next hearing. So there are many of them in the Mthatha High Court, for instance. You are likely to have more than 130 of such kind of applications, the applications to compel discoveries. Only on that date of the hearing, what simply happened, practitioners will stand up, produce a consent order in terms of which the application is withdrawn, the respondent is to pay costs. Then that application will come back again on the following, the same applications. Then it has been, one understands, of course, that most of the practices in the Mthatha area, particularly in fact broad Eastern Cape, they are dependent on what we would call a contingence work. So those applications, they are actually, the reason why there are so many practitioners want to quickly make their own cash is not really about these documents themselves. The idea is not to get documents per se, but is to make sure that you get these costs quickly. And then that has been a problem. I want also to draw your attention to the fact that when you read the Rule 6, you must rule together with the practice directives of the division. Because the practice directives, they give effect. They are meant to regulate or to give effect to the rules themselves. Practitioners simply ignore those practice directives. They just go on with their own application. Because what we require, or what at least is required, if you are intending to set down an application, you must give at least 5 days, 5 clear days prior to the date of the hearing of that application. Meaning that if you want your application to be heard that Tuesday, you cannot set it down this week, this Friday. You can set down that application this week so that we have the full 5 days, that is next week. Now we find that many applications are prematurely set down. There is no reference to the rule. There is no due regard to the practice directives. These are the serious questions. Then the last category I must speak to on this topic is the urgent applications. We have every Friday, we are almost guaranteed there will be, in the Eastern Cape, you bring urgent applications in 2 ways. If your application is to be heard on a day other than the ordinary motion court day, you need to prepare a certificate that you send to the judge, to the duty judge, to consider, decide whether it should be enrolled. Meaning that it's an application that is not going to be heard on a Tuesday. You want maybe this supposed to be heard on Monday, Wednesday, or Thursday or Friday. That one is clear. You must set out explicitly the reasons why you submit that matter is urgent and should not wait. Now, generally, the practitioners simply don't make proper certificates. That is, they do not set out clearly the reason why that application should be enrolled on a day other than a Tuesday. The result of that is that the certificates now would be declined. The judge will not issue the actual certificate. And we also propose or advise in terms of the directives that when you are applying, we are requesting to issue a certificate, you must make sure that you have a suggestion on how that particular matter should be proceeded. Meaning that you say you want the application to be heard at 3:30 and you set out how are you going to effect the service. You want the service to be email, you want the service to be delivered by the attorney himself. Those are the things that you should be setting out. Then that does not mean when you appear in court now, the issue of urgency will not be argued. All what the judge does is just giving you a right to institute, to proceed by way of urgency at that time. But in court, the respondent would be entitled to raise the issue of urgency, and that question can result on your application being struck off the roll if there is no urgency. There is a confusion now from colleagues that believe that once you are given a directive, then it means the urgency has not been issued. That's what we want to clarify. Lastly, if you want your application to be heard on a Tuesday now, not any other day, you don't need to make a substantive application, what you call certificate. You just file an ordinary certificate so that the matter can be identified that it falls under the urgent matters to be heard. Then all what you do, you simply prepare, you file a certificate, and it is served. These are very, very important, but when you deal with that, you must still satisfy the requirement that why this matter should be heard now, why you cannot be afforded redress at a hearing in due course, substantial redress in due course. This is what now practitioners simply overlook. Somebody will stay, I'll make an example, something happened in August. Mr. Mpofu come and argue that in one of the matters. Somebody's stay was suspended in August, November, December. All of a sudden in January, the matter comes up on the urgency, and the argument is that no, this matter, it carries public interest. It's actually, it involves the issues of administration, there are allegations of corruption and so forth. There's accountability issue. Mr. Mpofu said, no. If there are no detailed explanation for the delays. Those colleagues are broad issues. I don't know exactly what one would be talking about. The last kind of application under Rule 6 will be your ex parte applications, where you want to be admitted as an attorney. You bring that application ex parte. So all what we need to do is to send to the Law Society, it will check, but you don't cite another respondent. It's you only, because there are no rights of a third party that will be affected. So much as the application, I say. Now, reverting to this issue of Mr. Popokyana, I think Justice Spetzer started on that in the opening address. This profession brings on it serious obligations to the practitioners. And I would quickly read what the Judge Kroon, who was dealing with this particular matter, the remark exactly what Justice Spetzer has started with in his opening address. This is what he says in that paragraph 3 of that judgment. the courts have repeatedly emphasized that impeccable ethical standards are required of an attorney who practices law. He is to conduct himself with the utmost integrity and with scrupulous honesty. The Supreme Court of Appeal has further commented that the heavy responsibility which officers of the court are required to shoulder in upholding the Constitution is without parallel. This is emphasize the point that has been made this morning by Justice, this afternoon by Justice Spence. This is what is added in respect of this case of Popokyane. This unfortunately is a story of a dishonest attorney abating that responsibility and bringing disgrace and shame on the legal profession. What Mr. Popokyane did, he was instructed by Mr. Mohammed Mr. Mohammed was purchasing a property, and Mr. Popokyane was acting as sort of the seller in this property. He has appointed himself as a seller, and he took more than 2 million rand from Mr. Mohammed, and he deposited this money into a trust account, whereafter Mr. Popokyane started to make several withdrawings from this account, buying for the wife, paying for his personal vehicles, paying a lot of monies, distributing. Within a short space of time, the 2 million was almost done. And when a complaint was launched with the Law Society, with the then Law Society, Cape Law Society, and then the Cape Law Society requested some documents because as lawyers were obliged to cooperate with the Law Society because they were asking for documents, they were asking for books. Mr. Popokyane simply ignores the Law Society. Said, no, I refuse. I'm not going to give you any documents. We have no local stand because Mr. Mohammed had instructed an attorney to represent. I said, no. I have no dealings with you. We have no right to apply for this. So that is the upshot of this case. He stole more than 2 million rand, Mr. Popokyane, and in a systematic theft and fraud that he was committing, because he keeps on, because there was this amount of about 800 that has been left. Mr. Popokyane simply refused to end even that particular balance, even when, in fact, he has agreed there was this money, and he continued to chow even that particular balance. This is a very sad story, Now, the Law Society brought an application to strike him. By the way, he is now serving a sentence. He was not only that he was struck off the roll, but he was also convicted for the crime of theft and fraud. But this is what is important, what the judge, in dealing with that, trying to explain how the court goes about in conducting the disciplinary hearing of an attorney. I quote here. So, proceedings to discipline a practitioner are generally commenced on a notice of motion, but the ordinary approach as outlined in Plascon Evans is not appropriate to application of that kind. The applicant's role in bringing such proceeding is not that of an ordinary adversarial litigant, but rather to bring evidence of a practitioner's misconduct to the to the attention of the court, in the interest of the court, the profession, and the public at large, to enable a court to exercise its disciplinary powers. It will not always be possible for a court to properly fulfill its disciplinary function if it confines its inquiry to admitted facts as it would ordinarily do in motion proceedings. And it will often find it necessary to properly establish facts. That the facts were referred to the facts that give rise. That's the first inquiry, is to look whether on these facts, which is a factual inquiry, is the misconduct established. That's what the court has to look at. Then yes, this one committed fraud, this is enough evidence. Then it goes on. So the importance of this case, as we indicate, it talks to the ethics and the duty that is placed upon legal practitioners, advocates, attorneys, and all officers of the court. There is a particular bar to which we are expected. We are not just, as Justice Spencer indicated, we are members of an honorable profession. I'm not too sure somebody who just come, you mustn't accept somebody who comes to your honorable profession and make it dishonorable. You should resist. That's why members of the profession should not be kind to thieving lawyers, to fraudsters who find themselves into this profession. And also any conduct that is unbecoming of a legal practitioner. It should not be just overlooked. We have an obligation as members of this profession to stand firm in terms of protecting the ethical standards to which we are all obliged to observe. That's what the essence of this case is about. In conclusion, colleagues, the story of Mr. Popokyana is not an isolated one. There are many of those stories. We have had practitioners who use trust accounts to buy groceries, to buy for school fees of their children, to pay Louis Vuittons and all that. I mean, one practitioner, he went to Johannesburg, he was in those shops. I mean, I'm not sure where do they get even the cards, for instance, because a trust account ought not to have debit cards, but they do, some of them. The fellow was paying from shop number 1, Louis Vuitton, the other shop. Within a week, more than 2 million rand gone. And it's a young fellow who has just joined the profession. You must understand we have a lifelong in this profession. This is the future. This is the future of your own children. This is a future of generations to come. We must be one brother's keeper. This is what it is. If you see your colleague that has gone astray, you must be able to press and speak on him. We must assist each other. That's what Popokyana. Well, with those few remarks, I believe that at least I've tried, Program Director, to broadly speak onto this matter. But if there are questions, I will answer in due course. Mine was purely on the case, not to speak about big monies that my brother was talking about. Thank you so much.
Another round of applause. Yes, thank you very much. Yeah, hey, you guys are really looking beautiful. And thanks to the organizers, because I believe through this event, you've changed the economic status of Mthatha. If the bending down of Ipotastau decreased the economic value of Mthatha, by this event and everything that you guys have done, you have made a dent in the economy. Even though there's a difference between installing a value of installing a weave and by Chiscorp, but we are not judging of the contribution that you have made. Ladies, can you please give them a round of applause? You have used premium plastering. I'm still finding it hard. Are these my colleagues? Hey. Are these the people we meet in court every day? Hey, hi. But yeah, just another round of applause to everyone that has made an effort to be here. Thank you. Now, we are going to call upon the next speaker. And can we please warmly welcome Advocate Thembeka Ngcukaitobi SC to the podium. Come on, we're giving him a round of applause till he gets to the stage.
Enkosi molweni. Ndiyabulela ngale invitation yokuza apha. Ndiyabulela ke nomntakwethu beselapha wathetha. Ningawaziyo komntakwethu bangubani na? Oh, ake uyamazi. Yeah, exactly. Mr. Notyesi. Phofu ke undixelele apha evekini lobana kungabikho umuntu uthi Mr. Notyesi, nokuthi Justice Notyesi. Ndibulela ke no Bhuxola kanene nebancinci apha niyazi Justice Betsa basebethethi lapho wayekade phethe ke pha Supreme Court of Appeal kusithiwa ngu AP yeah, acting president. It means ke uphethe eza judge 23 sizonke. Yeah, wafika nase Constitutional Court wabhala ke pha i-judgments ezithile. Zikhona kanye endazixoxayo nam. Ndajonga i-judgment. Hey, ngathi ndiyazirecognize nje ezi lines. Anditsho ukuba i-heads ibizo ezikabani abhale ngazo kodwa ubhalile ke uJustice Betsa. Ngoku eza judgments zakhe ke zilanto kuthiwa i-precedent. Siyalandelwa. So welilizwe lonke usuke pha kwinto zokubana i-relationship phakathi kwe-mining ne-informal land rights ithini na. So njengoba nihleli ke apha niyazi uba nihleli nabantu abayisosi yomthetho. Uyaqonda. So ningacingi ubana nje hayi kwathini silapha kuyintoni meet and greet. Niyazi uba it's a profound moment. Ndibulise ke no Advocate uMpofu. Ndike ndibhideke ngamanye amaxesha umuntu akufowunele akubuze yemani udali kwathi umjonge le TV ndiseka ke undiyeke awubukela iTV wena ukwahlukana na because awuyazi mina i-relationship yami naye oba ithini na uzongena into ongayaziyo you know so because nalapha bendingezi ndifowunelwa ngudali hey masiye ndithi heke undinyanzela uba mandela you know so andiqonda ke noba andinaba sathi hayi ke nam xa uAdvocate Mpofu esithi masiye pha ndicomplainela yena but ke ndithe ndawufika apha ndathi ndiyayibona why ubusithi mandize apha kunjanje undincedile because bendilapha na last week so ndiqobe ndiyemthatha again kwathi but ke ndiyabulela kuba ukhona ke naye and njengoba undinyanzelisile uba ndize kule event ndiyayibona ke ivalue yale event now sendilapha ke hayi okay ndizuyithetha le ayihlekayo ndiyayazi kodwa ke ndithetha ngoba ivalue yale event ndiyayibona qha ndiphelele apho. Ndiyabona ke no Mr Sakhela ulapha ebesandoba kwenye icase ke in a couple of weeks ago eligqwetha uyaqonda kodwa ke kudala sihamba kunye asake sahlukana kula case siphinde sadibana ke ngoku sisahamba kunye okoko ukhona uMakhangela ndimbona naku uMakhangela abili igqotha lethu elia ligqotha lika Advocate Mpofu elia kodwa waye good man eTVini eanalyzing akanandanga athi uyabona i-contempt of court 15 months ejail but ke ndayithanda lanto leya because wawu-educative wawungekho personal you know so abantu babukela wena then umthetho bawazi uba you know qhuba ngohlobo ndike ndikubone kodwa nakwezinye ungena phaa ucomment so ndiyayithanda ke lanto uba because umthetho funeka ucaciselwe abantu aba-ordinary ungacaba yinto esiyi-owner sodwa
So abantu abafana ke no Mr Makhangela laa nto yoba zii-commentators very good. Bakhona abantu abacritical hayi ukutheni sethetha TV kuzawuthetha bani, you know, funeka ukuthethe nina ke Mr Makhangela. So ndiyayithanda uba ulapha kwathini. Kuthiwe mandizowuthetha ke apha ndiyazi uba kuthiwa ngizothetha ngantoni. Sayicinga ngento yomhlaba nomgaqo siseko uba zidibana njani na. Kodwa ke ndithe ndawuva apho nafumanisa uba ingathi le session yi-session ye-empowerment, siya-empowerishana nje, ayo session necessarily yoba sizopresenta ii-rules zomthetho kwathini. I think sophinda siyenze loo nto leyo ngelinye ixesha in a more informal setting apho sizawuthetha nge-legal principles uba zithini na. So zimbalwa ke into endizawuzithetha ke ngomthetho nomgaqo siseko uba ngomhlaba nomgaqo siseko. Umhlaba ke kuthethwa ngawo kumgaqo siseko ku-section 25. Ininzi ke i-debate about section 25 ne-origin yakhe etc. But the ultimate end point is that there were negotiations. I think abanye benu ke abayazi le nto ndithetha ngayo ye-negotiations. Before kubekho democracy between 1991 and 1993 kwakukho into ekuthiwa iCODESA, Conference for a Democratic South Africa, which comprised of representatives of the then white government, National Party, representatives of the ANC, representatives of the PAC, etc., in order to negotiate what the new South Africa will look like at the end of apartheid. Now, one of the most contentious questions in those negotiations was, what is the land dispensation going to be? Now, why that was important is because at the heart of colonial occupation was the taking away of the land of Africans by white people. The Eastern Cape, where we are, in a sense, is emblematic of the colonial seizure. You know, sikhulele eTranskei, but naseSiskei abanye. What we don't know is that the very establishment of these areas, or Transkei, no Siskei, were native reserves. You see, native reserves because of the Yabelungu, when they actually left in Cape, encountered the so-called Coloureds around Port Elizabeth, around Grahamstown, around East London, ultimately pushing them into the native reserves. As in Makai, they actually started off as native reserves as a consequence of the frontier wars. That's why I say end up esilapha nje sonke. Ebai naseMonti end up ekuhlela belungu. But even as natives occupied the Transkei, they didn't have political control. The control was still under the white colonial administration. But the actual land of the natives stretches all the way to George. You see, when you go back to 1806, you know, when the French Republic was proclaimed. But because of this colonial push. Now, the ANC's establishment in 1912 was informed by the need for African people to reacquire their land from the white settlers. This obviously transformed over time, and there were conflicts inside the ANC, and some people in the PAC left, etc. But by 1994, it was clear that you cannot have a democratic dispensation unless you've resolved the land question. But white people were not going to give up the land without a fight, because the land is the source of the wealth. It's actually the economy. Interest. You see, and this one must be reckless ngemali. But there is no one who's going to be wealthy by saving a salary 5,000 rands. It doesn't matter how many times you can save it. You know, if man a low interest, it's impossible. Right? Nabelungu aba who control Liberty and Sanlam, and Standard Bank didn't get wealthy by saving 5,000 rands a month. They got wealthy by occupation. Right? So until you actually resolve the fundamentals of the economy, which is what we should actually be using this constitution for, if you want to really change the economic landscape of South Africa. So ndifuna ke siqiniseke ubana simka ideologically si clear ngento ba yes, you need to look after your income, but you must understand ubana the real wealth of this country is in the land. Uyaqonda? Now kwathiwa ke ngo-1994 makubekho a predecessor ka-25. I think it was under section 23 of the interim constitution. But there was a problem that the starting point of the property clause was that all of the wealth and the properties acquired under apartheid would not be immediately transferred to Africans. It would be kept by white people. Okay? That was the starting point of the negotiations. We always ought to be clear about that, that the premise of those negotiations was that there would be no transfer of wealth and no transfer of property as a precondition of freedom. It would still be in the hands of white people. Instead, there would be a dispensation through which a constitution would enable what is called claims, a land claim, which required that you need to prove certain jurisdictional facts in order to succeed. And the main jurisdictional fact was that you could show that yourself or your family were dispossessed as a result of racially discriminatory laws of the past. Okay? Now, you can see the way I'm putting this thing, that it's actually ridiculous. Because if you are dealing with a colonial encounter, you have to assume that everyone was dispossessed. But the way the system was designed was that each individual must go and make a specific family or community claim by proving the fact of dispossession. Okay? Which I think was actually the first problem. The structure of it actually made it impossible to transfer the land on a significant scale, which was the process of land claims. Ikhona ke phaa section 25 into ye restitution. That's the one leg. And then they knew into yobana now izaba ingxaki yonke lento, because where do you start and where do you end? Because abanye abantu bathi maqalwe ngo-1652 ufika kwa-Van Riebeeck. Abanye bathi even earlier than that, ufika kwe-Batavians. Abanye bathi ngo-1820, etc. So there are many competing days, but where do you start? Kwathiwa ke ngo-1994, no, masiqale ngo-1913, ngenxa into yobana kwabakho umthetho kwakuthiwa i-Native Land Act. Laa mthetho ke usection 1 uthi xa uyi-native awunawulungelo lowuthenga umhlaba kwindawo ekuhlala kuyo i-Europeans. Xa uyi-European awunalungelo lothenga umhlaba kwindawo ekuhlala kuyo i-natives. Na uzibuza ubana yeyiphi indawo ye-Europeans apha, yeyiphi indawo ye-natives. Uye ke ngoku-schedule. I-schedule ke ixelela ubana 93% of the land ye-Europeans, and then 7% zezi ndawo ke kwakusithiwa zii-native reserves, 7% ke yeyethu. So which meant that effectively you could get permission theoretically by going to the governor, uyocela permission, but the statistics show that no permissions were ever given, okay, because that was a political law. So this is why ke kuthethwa ke kuthethwa ngo-87%, but the initial legislation ka-1913 yayithetha ngo-93%. Ijikwe loo nto leyo ngo-1936 xa kusenziwa i-amendment kula Native Land Act, sanyuselwa nje kancinci sanikwa i-6% ubana sizofika ku-13%, abelungu bahlala no-87%. Now bengamthathanga ngelakhi, it was carefully planned, it was scientific. Kwajongwa indawo ezinobutyebi, kulandelwa i-rain patterns, kunetha phi kakhulu, imilambo indawo nina kakhulu. That is why nihlala apha emagqagaleni. You see, ukuze kudesignwe i-native areas kakuhle, uyaqonda. Otherwise ubana kuzawunikwa nini indawo ezingaselwandle, iyaziwa into yobana kuzawubakho ingxaki. So there was a scientific process to select ubana zeziphi native areas and zeziphi na European areas, because some of these things don't make any sense. Ubujonga iSiskai neTranskei yabona bazohlulakela ingathi enye i-island and then enye lapha and then in between kubekho South Africa. So uzibuza by logic ithini, because befanele bakaloku is seamless, kufanele ngamaXhosa onke, you know. But the logic of it was that lamhlaba between iSiskai neTranskei ubone ubutyebile, so mawuhlale ebelungweni. And then naxa usenyuka ngapha uyodibana neMatatiele, uyodibana it makes no sense, because kwakuthiwa lokho izaba indawo yamaXhosa lena efakwa nabeSuthu. What is going on, you see? So it's part and parcel of the apartheid logic into yobana makubekho i-fragmentation yeli lizwe. Lo fragmentation ke iza kwenziwa according to wealth. So at the heart of it was how to distribute the wealth of this country. Kwafakwa ke umthetho ke as a sort of legitimation, because xa into esemthethweni siye sicinga by common sense mos andithi xa ibhaliwe umthetho no that's how it is. Kuthiwa why it's because umthetho utsho. Now then ke kwathiwa ke ku-1913 i-cut off date uba udisposeswe wena ngo-1912 awusengxakini. Budisposeswe in fact ayinguyena 1913, it's the 19th of June 1913. So budisposwe nge-18th of June awusengxakini awungeni, yaqona. Yayi-compromise ke leyo which also is illogical, kodwa ke yasayinwa into the constitution. And then the last thing ekwathethwa ngayo kwathiwa if une-process ye-restitution eqala ngo-1913 bakhona abantu abazaba outside i-restitution, bazawufumana njani umhlaba. Kwathiwa mabenzelwe into ekuthiwa i-redistribution. So bazawucela kurhulumente, urhulumente uzohamba ayothenga umhlaba kwi-market and then awugcina umhlaba and then amane benika ke ngoku one by one. Yile ke yenze i-corruption eninzi. Land okuthiwa i-redistribution, corruption ininzi ukufa. Now the consequence of all of this thing is that you have a failed land restitution and redistribution system. You've also got a failed system of creating wealth equality between abelungu nathi, because the base of the economy sesezandleni. And the result is that sicinga into okokubana ngoku kufeyile lo mgaqo siseko. What we are not asking ourselves into yobana ibikhona na i-prospect of ever succeeding on this issue ye land, or whether fanele siyidesign afresh. Now I don't have answers, but I've had an opportunity yoba ndi-act phaa Land Claims Court. Ndazikhupha mna i-judgments zajikwe e-SCA. Ukhona uJudge Betsa ulapha. So andiyazi ke ngokuba kuthiwa masithini na ke ngoku, you know. So that's why kuyo ngoku into okubana kwakuthiwe inkululeko yethu izawexpresswa through a constitutional system. Yaqona? In other words, it's going to be judge-led. Sazibhala judgments. Sajikwa. Urhulumente akaya e-constitutional court ayo-aphila pha. Kwenye ngoku i-judgment ibisanophuma yecase ekuthiwa I think iSanral. Sibuyisela back nayo ngoku to uDutoy. Yazi case kaDutoy versus Minister of Transport. Yeah. Sibuyisele back ngoku actually it's worse than Dutoy. Ibiphuma ngoku Supreme Court of Appeal around compensation on expropriation cases. Yabona singathetha ke kuyosa about the illogicality of applying a market standard in an expropriation where there is no willing seller and there is no willing buyer. I-SCA yenze enye ke ngoku 3 weeks ago yenze enye, you know. Ekufuneka siyijikile xa sifumana i-opportunity. Yaqona? So ndizama ke ukuthi ke icekwa linani yokubana ke nizithathe ezi cases zomhlaba. Wayeke usakhela manje ndifowunela besithi une-land claims xa ndijonga zindoni hey apha emthatha kubi izimbane kuthiwa yonke iyaklenywa ngubani hey ndiqonda uba andi-understand baqhubeka ntoni. Then nathi phaa ewusu mos sinomhlaba phaa sivile hey kumkani kuthiwa iyawufuna lo mhlaba. we are providing a public service of educating children who otherwise would not have access to education. And then kube kuthiwa kukho umuntu othi ufuna uthatha wonke university. Now the problem with this thing is that silwa sodwa ngoku ngomhlaba omncinci we-natives siyabelungu phaa nasebhayi. You see, nansi problem ke siyi-confront qha ke naleyo andifuna uyithetha kakhulu because kuzawuthiwa kwashawa cima. So ndigqibile ke into yomhlaba ngoku nomgaqo siseko ndibeka nje i-challenge into yokubana i-design esasinayo ngo-1994 ayisebenzi, ifuna ukureconceptualize. Abantu abazawuyenza loo nto leyo nini, thina besiyizamile yethu sifeyilile ngoku. Sixelelwe phaa e-SCA into yobana ayiqhubi ngolu hlobo, sithule ke ngoku. Phaa ufike mhlawumbi saphinda siyibambe kwenye icala very soon. I-process yomthetho ke is very, very slow. I-process ye-adjudication is very slow. Ifuna ne-patience, but ifuna ne-principle. Now, I think ndilithatha lonke ixesha lam on topic 1. Utopic yesibini is section 47. Now, section 47, I think mandinike u-advocate Mpofu azothetha ngaye. Kuba kaloku waqala applicant electoral court. Wawina phaa, dade madoda, yinto enjani lenzekayo. Umuntu abeconvictwa izolo ngoku sele zawustenda kwakhona. Hayi sa-aphila ke-Constitutional Court, sawina ke phaa. But ke Mr. Mpofu is the original thinker of the complexity of Section 47. Most of us thought it was actually an easy section, but I think that the judgments have shown how complicated the section is. Abangayaziyo ke ila section ithi uba ubuke wane conviction was sentenced to 12 months without the option of the fine. Awuzokwazi uba ube imember yeparlament. Ibuyile ke ngoku invoke ngenxa ke case ka Mr. Malema. That's why ikwi-public again lo discussion le. Uyile ke kwathiwa uMr. Zuma akazukwazi ungena eparlamente ngayo. That's why ndisithi oyena muntu uzaba right uba ayicacise usebenza njani na ngu-advocate Mpofu. So xa ixesha lakhe lifikile ke angazothetha. Mna ke into ebendifuna ukuzithetha ayizezi kuthiwa mandithethe ngaso. Bendifuna nje mna ukuthetha ngento yokubana njengamagqwetha asaqalayo zeziphi na ii-tools efuneka sibe nazo so that sizokwazi uba successful kwi-profession. Bendifuna uthetha ngazo nto ezo mna. Kuba ndikhumbula ndisesi-student apha e-UNITRA, I think ndandisenza i-BPRO ngelo xesha. Si-invite u-advocate Madlanga, SC. I think he was a senior counsel at the time. No, wayengo-senior counsel, waye-junior uBudras. Ufumene uSilke eGoli, yes, I remember now. Or I may even be mistaken, I don't know. But ndikhumbula sim-invitile sisi-students. Uba azosiadressa. Wasi-adressa ke at length. But one of the things I took from that lecture yakhe into yobana kule profession akho nto zamahala. Kufuneka usebenze very, very hard and ungacingi into yokubana kukho i-shortcuts. Ndiyayi-understanda ngoku into yobana inintsi into yoba xa ujongile uba ubani kwasha kwacima uthenge imoto. Yeyakhe laa moto awuyazi uba uyithenge njani. So sukuzifaka wena ekuthengeni kwakhe imoto. Kuba le yakho ilane. Kuba enye yezinto wazithethayo uBudras ngalamini into yokubana apha asikho kwi-sprint, sikwi-marathon. You know, sikwi-marathon asikho kwi-sprint. Ingxaki ebangela ubana singene ezintweni esingakwazi uphuma kuzo. Into yobana sicinga ubana sikwi-sprint. asi-understand into yokubana funeka uzipheyise, uyaqonda, uzipheyise ubana namhlanje u-rule 6 andimazi kodwa ngomso uzawuthi efika ungomso ndizabe sendimcula, uyaqonda. Andizuye enkundleni ndingakamazi u-rule 6 uba uthini na kanye kanye ii-provisions zakhe. Now, one of the things I've learned into yobana most of the things in law can be self-taught. Yabona e-unit yakufika nje ii-lecturers zithethe ziphume ii-lecture ungazi uqhubeka nto usemtshabi kuthiwe belapha heyi asimazi uba uphumile. Wayeyi-lecturer naye phaa kuthi e-unit Botman afika athethe hambi noqomba yeyi andiyivanga noba bekusithwani na apha. Nyani kuphela 6 years ungayi-understand uba bekusithwani na uqomba uyipasile civil procedure but awuyazi senjani, you know, yeah. Now, this is the point into yobana I learned a lot of the things can actually be self-taught. Ndafumanisa ubana funeka ndihlale ndodwa phaa iitshomi zingekho ke ndiyifundisise le nto ndiyi-understand uba ithini na, and then ke ngomso ke ndiyoyipractice kancinci ndibone. And I also learned the benefit of observation. You know, ngoku ndandisaqala, you know, ndandihlala ekhoti ndibukele abanye abantu bethetha phaa, ndihleli phaa ndiyijunior ndibukele naku Mr Mpofu ethetha. Yabona ke xa ungathethi ngokwakho kulula ucinga into yokubana ilula le nto yenziwayo apha, you know. So ndihlale ke because ndiyijunior ndimnikele yeyi tali thetha le angayithethi ndicaphuke benomsindo, hayi kutheni engayithethi le nto. Until unikwe iscript ngokwakho, you know, ubathetha uqaphela uba yeyi umcimbi lo unzima. Kodwa ndafumanisa into yokubana there is a benefit of learning by observation. Xa uhleli ecaleni komntu ubukele ngomso nawe uqonda uba make ndiyipractice le nto before uyowuthetha. Aba bantu bafuna uba zii-advocates, ube uke uthathe isipili esikhulu usibeke apha phambi kwakho, uthethe sonke ispeech sakho uzasinika ii-judges, usijonge phaa kuwe into yobana how does it look like. Uzawubhuda in the first minute, uzayi-understanda uba naxa uthetha phambi kwejaji uzawubhuda ngalaa ndlela, yiphinde kwakhona until uyeka ubhuda. Uzawuthintitha, yiphinde kwakhona until uyeka uthintitha. You see, uzawulibala icase, yiphinde kwakhona until ungayilibali. You see, so that xa ufika phaa ejajini abantu ababukeleyo bathi yeyi umagrazula lo, abayi-understand ubana yi-6 hours ye-preparation. Now ke asifuni uyenza ke laa preparation because sibhizi ngezi shortcuts and siya-overtrade, zininzi icases esizenzayo. Asi-understand ubana kanti ufuna nje case benye, one case. Abantu bakhalaza kakhulu apha, umntu athi no andifumani umsebenzi. Akukho gqwetha lingazofumana umsebenzi, uzawufumana at least one case in your life, one. Now funeka uwine laa case unayo, ungafuni le yam icase, yenza le uyinikiweyo uyiwine. Noba icase ikwamantyi emqanduli, andinangxaki ngumqanduli, mandithethe ngecala. Benzenza lo mzekelo, noba icase ikwamantyi phaa kuthi ecala, amboyiwina, then ubuye ke ngoku uzothetha ke ngokunathi ube une-case oyiwinileyo. Awuzufuna ukuya e-constitutional court ungazange wawina case kwamanje. You see, isebenza kanjalo le profession, awuvele uthi gqinje so unansika. This is why ke sometimes, you know, ndizawuphinda ndenze omnye umzekelo ngo-advocate Mpofu. Phaa e-constitutional court azithi judge zihlala phantsi Mr Mpofu kudala uthetha. Why? It's because he has inculcated respect for himself over the years. You see? Now awuzufika wena phaa kulaa ndawo ufike uthi kutheni ngahlaliswa phantsi, mna ndihlaliswa phantsi. Ndangxoliswa mna ngu-Chief Justice phaa ndiphendule ijaji. Uba yes uyiphendula kanje le jaji. Hey, okay, ndiyakuva ke Chief Justice, cela uxolo. Abanye kodwa ke bathi aqomba andingendawo kuleyo. Because andikafiki kulaa level. Eyam iminyaka iseza nami into yobana ndifike kulaa nto uba kuthiwe no ungakwazi, you know, ukwenza eso speech ngaloo ndlela. So ndiyafuna ke ukuyigxininisa ke le ndawo yobana funeka uzazi istation osikuso, i-humility yena ndizawusinceda. Into masingazingxameli, And as most of these things, we can actually do them. Xa singazingxamelanga. So zizinto ke ebendifuna uzithetha ke ezo. Into nayo ndimoshwe ngaba section 47. Nento zemithetho. Because mna bendicinga ubana ndize nokwana as an elder, ngosendiyi-elder ngosmo. To give a few words of support. Ndifuna ubulela ke before ndihlale phansi aba bafana bebe-organizer le event yanamhlanje. Kuthiwa ke bebekhona nabantu abangosisi kodwa mna ndiconductwe ngumfana wathi ucela uze apha. Ndithanda into yobana nithathe i-initiative ningalindi kuthiwa silinde iNadel, silinde i-BLA, silinde into ethile nethile, nizenzele kuba kaloku le profession inkulu kakhulu for uba silinde i-formal structures for uba senze umcimbi olohlobo. Ndifuna ke noni-encourage into yokubana the future looks bright. Yeyenu ke to take it and grab it. Chini naku noTiya, ndiyambona ngapha. Tiya! Yemato. Ndisandomnika umsebenzi lo pha eWusu. Kodwa uyasebenza. Nimbonile kodwa emaphepheni uba okay kuthiwa uboniwe Tiya uba uyi-secretary ye-Drafter Commission. But ke yeke le andizothembisa abanye abantu ngomsebenzi. But ndibhizi phaa ndenze empowerment noma khangela apha makhangela ndivile kuthiwa kwipanel yethu naye kuthiwa makenze i-disciplinary hearing awukadilivarishi makhangela isalendiwe la DC. So abanye abafuna umsebenzi bakhona abafuna umsebenzi. Andizuyithetha kodwa ke funeka ungene kwipanel because sine supply chain policy phaa esiyilandelayo. But ndiyafuna into yobana abantu ababefunda eWusu abane-firms bangene kwi-supply chain yethu. Laa nto yobana anaproblem into yobana kuthathwe abelungu baseBhayi naseMonti if ba-good. Kodwa it's impossible into yobana ezi zinto ze-labor asizazi mana ayibo. Siyazazi ezazi zinto ezi. So funeka siyidiversifye i-panel. So ndifuna ukuthi ke yidimandeni laa nto yongena kwi-panels zethu sizokwazi ubana umsebenzi siwudistribute. Bendikubulisa nje Mr. Tiya. Bekungekho nto bendingakubonanga initial otherwise ngeke ndikurecognizile. Uyi-leader mosuTiya weNadel. Yeah, so funeka i-leaders nizi-respect. No-chairman weNadel ulapha umntakwethu. National chair uMr. Notyesi. Justice Notyesi. Andingayithethi ke enye. Ndiyacela ke ubulela ubana ke nikandikhulula ke ngoku. Ndicinga ubana umsebenzi ebendiwubizelwe apha ndiwugqibile. Bendicinga uba ke kuzawubakho i-question and answer. Mhlawumbi ke iyawulandela emva kwa-Mr. Mpofu. Enkosi.
A round of applause. Yes, siyabulela kakhulu. We are really grateful for your opportunities ezinje. It means really a future of illegal practitioners eMthatha ibright kakhulu. Advocate Ngqaithobe eSindi nami ndingatsho I think bangangqina ngabaninzi. Ubhotma yena asekamvuma ngoku kodwa ke i-degree sinazo. Sakhangela icebo. Andazi noba ufuneka nikwe isipili na. Akhaye isipili kodwa ke sinazo i-degree nazo sinazo sakhangela icebo. Yes, now we are going to move on. Masike siphinde sibuyele phaa kwi-insurance futhi. Ndizawucela ngokusamkela uSanlam Mr. A Cingo esiza ngaphambili. Sizamqhwabela kuMr. A Cingo athi azofika apha ngaphambili.
Hey, ningabi navala ndizubanda. Ndiyabulisa to all our esteemed guests, to all our leaders, and Noko, I'd like to keep it short and say all protocols observed. igama lami ndingu-Ada, ngu-Ada Duma xa liphelele wakwaCingo, ndingowaseLusikisiki emaMpondweni. I'm here with my two colleagues, Mrs. Lereng Nonchiza, born and bred up in Tata, no Mr. Odwa Ntisane, ngowaseDutywa. We are representing Future Vision Blue Star Financial Advisory Services. It is a Sanlam franchise, specialized with professional financial planning and estate planning for professionals and businessmen and women. We are based in Durban, Mhlanga, but we travel all over the country, assisting clients and assisting people live with confidence. We are in the process of opening our branch in East London, ezohedwa Mrs. Nonchiza here on my right. I think ningahlala phansi so that it go back. I just wanted you guys to see the faces. Ndiqale ngokubulela to the organizing team for inviting us this year to be part of the sponsors. And thank you very much for the opportunity as well to be able to address the crowd and just give a small glimpse of who we are and the services that we offer. A very big part of our business, to keep it short, focuses a lot on investments. We have invested in the past 10 years around 700 million in assets under management. 80% where the investments come from road accident fund matters, medical negligence claims, and ESCOM-related settlements. Ngeba askwazanga kwakuraiser lo 700 million if it wasn't for attorneys that refer business to us, but most importantly, entrust their clients with us. 80% of 700 million is over $500 million yemali ze clients esekhona. Because if we hadn't met these clients, chances are ngeba isekho lo mali, because we know how the clients spend their payouts. Isekhona lo mali, most importantly, it is growing well. And it is well protected. We don't just invest for clients. We also educate them about generational wealth. We educate them about the risks that comes with having such monies. Siyaba educate marital regimes, the differences between okwam, ngokwakho, okwakho, ngokwam. And we also help them drafting wills and open trusts. As clients have once been your clients and you settle those matters and you entrusted them with us, they are clients for life. Their children are also our clients, and their children's children will continue to become our clients. And thank you again for entrusting us with those clients. I would also, as well, make an example of my very first client in 2014 when I joined Sanlam. The client I need 2 million. Right now, the client has just over 8 million. Une income and has made a couple of withdrawals for emergencies over the years. In closing, I'd like to make an example of a conversation I had with Igwete Ngqale ukusebenza nalo about 3 years ago. Noko ke seyisebenzile umhlekazi. Because obviously xa undifera kwi-clients, as much as I'm not allowed to do it, ndiyawubala man la 25%, but okay, 25%, okay, 25%, okay, 25%. Ndambuza umhlekazi, wena mhlekazi, where are your monies invested? Wazothi Fago, because sometimes because sometimes matters take time to settle, I need a we need to diversify our investments, benezinye income streams. So I've invested most of imali zami into property. I own 1 or 2 malls, I own 1 or 2 buildings. Illiquidity yok investor nawe anayo. I'm busy finalizing another project as well. So ndimbuzo umhlekazi ba okay, xa ubala zonke ezi property and the investments you've diversified into, mhlawumbe ungathi how much you spent. Wathi xa wanjonga wathi around 200 million. Hayi ndaqonda ba hayi uba modest ke, but it's not my place. Ndithi okay, and how much liquidity do you have currently? Wathi hayi inoba ifiyanga naku 5 million. Ndathi kuyazi mhlekazi, if we had met 10 years ago, you would have still had the 200 million in liquidity, and you would have still built as diversification, as property, as molanyana is worth 200 million. Hey, he took one step back and said, ah, yeah, go. So I made a small calculation that I'd like to share with you guys and then do a shala pants. Imagine 200 million invested in one of our offshore portfolios. This portfolio has been averaging between 17 to 22% per annum in terms of the interest in a return. But for the sake of ease of calculation in this example, let's just work on 20%. Kule portfolio, you are allowed to borrow 50% of a portfolio's value yako. So that unga withdraw 100 million to build, and then you are left with no liquidity. So picture 200 million invested, ayiboleke kumhlekazi 100 million to build his properties. The percentage that you are charged with interest yalo investment is prime. Prime currently 10.25, but let's work on 10%. So la 100 million is 10% ngonyaka. Awuna monthly debits, ungayibhatala nanini na, and ayibala nokubala ku credit bureau because we have your investment as security. So if la 200 million makes 20% that year, the following year sihleli ku 240 million. But ke la 100 million awayibuyisa imos and isa charge interest ka 10%. 10% ka 100 million ngu 10 million. So on the 40 million you made on your 200 million since ungayi withdrawanga, minus la 10 million year interest, overall the portfolio yakho ikhule nge 30 million. So year number 2 you're on 230 million. Siphinde futhi singayibuyisi la mali, si add 20% to 230 million. We're on 276 million. Minus 10 million yala mali uyibolekileyo ungekayibuyisi. We are on a net of 266. And then ngonyaka wesithathu si add into 20% wokugqibela, and we could be sitting at around 319 million. Minus 10 million imali ongayibuyisi, we're sitting on 309. Uthathe le 100 million extra yenzileyo, usettlishe debt yakho, you've got your 200 million and a property built ngemali oyibolekileyo. The figures I'm using is an average. I could sit down on a one-on-one and give you more examples. And as much as ithetha ngo 200 million, the portfolio can start as little as 500,000 and we can use the same concept. And imagine repeating the same concept all over again. Unganayo liquid yakho and invest in the land, ebaligileyo, and the property and diversification. So in closing, please do engage with us to talk more about other services that we offer. And luckily, Umhlekazi, my colleague, has touched on more. So for the sake of time, I thought let me just share one or two things with you and be very short. But we are around. Please engage with us. And we look forward to working with each and every one of you all. All the best to the new candidate attorneys, and thank you very much for having us. Siyathemba usibana next year silapha, and I'm sure we're going to double or triple the sponsorship. Thank you very much.
Ezandleni, can you please clap hands for Mr. A. Gringo? Yeah, niqhwaba kakhulu apha Mr. A. Gringo, nanoba niqhwabela la 200 million okanye angikho sure. Yeah, but ke mna ngicela uhlale phansi nami uzongicacisela ngale 10,000 ithini umcimbi 200 million akusekude. Now we have umntu that osiphethe sonke apha, and now we're going to welcome a guest that we should all bow to wherever sidibana naye. Can we please warmly welcome Mr. A. Warner as he comes up, please. Ezandleni.
Thank you so much, Program Director. Good afternoon to everyone present this gathering. First, I would like to thank Mr. Maduna and the team who have been communicating with me to ensure that I'm here amongst you today. I've been invited in my official capacity, so I'm not here in my personal capacity, but in my professional capacity as the director of the Eastern Cape Office of the Legal Practice Council, which is one of the 9 offices established in terms of the Legal Practice Act. Before I proceed, I would like to recognize the judges that are present, Justice Petse, Justice Nochesi, as well as Advocate Mbofu SC and Advocate Mugaitobi, and to all the guests that are present, with all protocols observed. And lastly, in my recognition, I think I will be remiss if I don't recognize Mr. Tia, who is also a member of our National Council. When I was invited, I was not given a specific topic to address you on. Mr. Maduna advised me of the composition of the audience, and knowing the issues and the questions that usually arise, and I decided to talk on a topic that is going to cater for everyone that is present here, and in the process to ensure that any uncertainties are clarified, any questions or any issues that the legal practitioners and aspirant legal practitioners have are clarified or in this topic which I will be addressing. It's a simple topic. The topic that I've chosen is the mandate and the role of the LPC, because I found that there is a confusion and many people are not aware or do not know our mandate and functions, where it starts and where it ends. I think it is important when I am going to deal with that process just to give a little brief background. The LPC is a creature of statute. It has been established in terms of the Legal Practice Act, right? And as a creature of statute, it derives its powers and functions from the Act. You know that if we are a creature of statute, we cannot do anything that is not covered in the Act, right? And its mandate is to regulate the profession, and the mandate of the differs from that of the law societies that were established in terms of the what we call Attorneys Act, in that the Attorneys Act expressly provided for the law societies not only to regulate the profession, but also to represent the interest of the members of the profession. Now that has changed. Under the Legal Practice Act, the Legal Practice Council is a regulator, right? It is a regulator. It does not represent the interest of legal practitioners. It is for that reason that in the past, every year, the law societies had annual general meetings at which decisions on issues affecting legal practitioners were taken, voted, and agreed upon by members. So that platform is not available and is not provided for in terms of the Legal Practice Act. Having said that, the council does take into account, even though it does not represent the interest of the legal profession, or members of the legal profession rather, in the decision-making process, we do take into account the interest of the members of the profession. So that role of being a representative of the members of the profession is or has been taken by voluntary associations such as LSSA, NADEL, BLA, the bar councils which continue to exist in terms of their constitution and what to call and the rules. So what I want to say is that it is important for members of the profession, to organize themselves through voluntary associations and supporting those structures actively, so that you speak with one voice on any issues that affect the profession. So the LPC took over the regulatory component, right, of the profession from the law societies and the bar council. That regulatory component, which I'm going to explain now, is from 1 November 2018. Right, so that regulatory function is performed by the LPC, which does not own us. When I speak of legal practitioners, I speak of attorneys, advocates, right, and as well as aspirant legal practitioners, those being candidate legal practitioners, including the pupils, right? Those who are aware, they will know that the rules under the Attorneys Act, specifically provided for the establishment of attorneys associations and circles, and the law societies, in finalizing the budget, the interest and the work of those associations was taken into account. So they've got a very, very critical role to play when it comes to dealing or representing the interest of the members of the profession. And I wish that all practitioners, they will support those structures. What I want to say is that, or before I go there, I think I found it necessary that I make a point that the regulatory component of the profession is that of the LPC. I'm mentioning this because our jurisdiction as the LPC, especially when it comes to investigation of allegations of misconduct, has been challenged, and on the basis that we don't have jurisdiction. So we do have jurisdiction over all legal practitioners. Despite the changes that have been brought about by the Legal Practice Act, the profession remain independent and it is self-regulating. What do I mean by that? The legal profession is regulated by the council at the national level and provincial level, right? And the members of those structures are nominated and voted upon by legal practitioners. And the term of those members of the council is 3 years from the date of their election. What we have noticed during the nomination process and the voting process is participation by practitioners in that process in terms of nominating and voting for people who must sit on council to regulate their affairs is not big. Many practitioners don't participate in that process. I want to point out that all legal practitioners who have been admitted as such are eligible to participate in that process. I'm hoping that in the future this participation will increase and improve. As I've indicated, that despite the LPC not representing what you call the interest of the legal practitioners, it is still a self-regulating or regulated profession, right? And the manner in which it is funded, it is through annual subscription and appropriation from the bar council. So when it comes to payment of subscription, I've realized that there may be a confusion which I need to clarify. You'll remember that some voluntary associations, to be a member, you must pay that membership fees. So what has come to my attention from the legal practitioners with whom I've discussed this issue is that once they've paid, a membership fee to their voluntary association, they think they have covered the subscription fee. Now the subscription fee is payable to the LPC over and above the membership fee that you pay to the voluntary association. So the legal profession, like any other profession, has got rules and the laws that govern it. Anyone who join, or who aspire to join the profession is expected to adhere to those rules and comply with them, as well as the code of conduct. The council, I think it is important that I mention this platform that every time the council has to take a drastic step to enforce compliance or for non-compliance, when I'm speaking of drastic step, is suspension or striking off, does not rejoice. They are saying that they've got to suspend or strike off a legal practitioner for non-compliance. That decision is taken as a last resort after the council has considered, the issue at hand and all other options that are available. It is not a decision that is taken lightly, and I want to say that LPC, whilst it is a regulatory body, is still your organization. It is your LPC. You must not be afraid to contact our offices whenever you need guidance or are uncertain on how to approach certain things. The problem that we have is when we seek information or we want a response from a legal practitioner and we don't get a response, then the council is left with no choice but to accept the one version that is before it. So it is important to respond to that communication, because I don't want legal practitioners of the LPC. Our doors are open. You can approach us anytime. I don't mind personally, even when I'm being contacted on my cell phone. It is not an issue for me. Right? So for those who aspire to join the legal profession, either to be attorneys or advocates, you need to have in place a contract of practical vocational training, and your principal or training supervisor or mentor must be a legal practitioner, right? And if you look at the definition of a legal practitioner, you will find that it says a legal practitioner is a person who has been admitted by the High Court and enrolled, by the LPC. So what that means is that admission alone does not make you a legal practitioner. In order to qualify to be a legal practitioner, the next step, once you are admitted, is to appear, because we are required to keep a roll of legal practitioners. You are required to register with the LPC and indicate whether after admission are you going to be practicing or not. If you are going to be practicing, you will give us the details of where you are practicing, as well as a copy of the court order. So enrollment or registration with the LPC is very important. And the next important thing is that I think this is for those who train candidate legal practitioners, being attorneys and advocates. We have come across, in many instances, that when we receive contract of practical vocational training for registration, that the person proposed to be a principal or training supervisor does not appear on our roll. So I want to ask legal practitioners, before they conclude, so that the candidate legal practitioners are not prejudiced in the process, not to hesitate, because that information, the role is also available on our website. You can check and verify if this person is indeed or not. Alternatively, you can confirm with us at our offices. So that contract, from the date of signature, we have got 2 months within which you must submit it to the LPC for registration. If you don't submit it within 2 months, then unfortunately the commencement date is not going to be the one recorded in the contract. It will be the date of registration of that contract. Right? I think the next issue that I want to cover is very, very important. You can enter into a contract of articles for a period of 1 year or 24 months for those who want to become. And for pupils who want to become advocates is 12 months. Right? Is 12 months. So what the law says is that candidate legal practitioners can appear in the district court and in the regional court, in their second year for those who have got 24 months. Right? If you have got a contract of 1 year, you can only appear in the district court. And I don't know how this is going to be received, but I think I must mention, because I don't think it is happening. The regulation says that, I don't know whether it is an error, but it is there in the Act. I want to point it out. It says that if you are doing pupillage, you can only appear in the district court and appear in the regional court after completing 6 months of your pupillage. And there is no provision in the Act, because the rule says you can appear in any court or tribunal as long as it is not the High Court, SCA, or Constitutional Court. Right? After the expiry then of that contract, and let me mention perhaps this important requirement. It is a requirement for admission. You are required to complete a structured coursework program if you are going to be an attorney of 400 notional hours or 150 notional hours. And that requirement also applies to those who want to become advocates. And we do have various organizations that have been accredited by the LPC to provide that training which is required. Right? So once you have passed, I'm still going to deal with the examination. Remember that after your contract is expired, you can no longer continue to do the work that you have been doing as a candidate legal practitioner, because that tantamount to you holding yourself out as a lawyer. You must wait until you are admitted. If the firm wants to keep you, you can be kept, in a position not as a candidate legal practitioner, but in an administrative capacity. Right? It is an issue countrywide because we have had many cases being referred to us by the judges where a person whose contract has expired appeared, and on review those proceedings are nullified, and that case it has to start afresh. And that case has to start afresh. So when you apply for admission, then the council must grapple with, because of that conduct, it must grapple with the question of whether can you be considered a fit and proper person in light, because appearance without the right of appearance in a representative capacity is a criminal offense. So it requires then the council to consider if you are fit and proper to be admitted as a legal practitioner. So I urge those who are candidate legal practitioners and those who are yet to join after the expiry of the contract to please not to continue what we call appearing in a representative capacity. Because we don't want as the council, to find ourselves having to prevent you from joining the profession, because the mandate of the LPC is to promote access to the profession and to remove any unnecessary or artificial barriers of entry to the profession. Right? The other question which has been asked for admission papers, especially for those who are pupils, is whether for admission purposes, do they need to write both examinations, meaning the bar council exams and the LPC examination? So the answer to that question is a no for admission. The LPC examinations are sufficient. Because as I understand it, in terms of the rules and the constitution of the Bar Council, you write those bar exams only if you want to become a member of that bar or the relevant bar, right? And when you bring that application for admission, especially if you are going to be an advocate, I think it is advisable that you also serve a copy on the relevant bar councils, especially if you will be becoming a member of the bar. Right? It is important to have that application served on them, and the application must last our offices for a period of not less than 30 days. Right? And now I want to touch on the issue of examination, an issue that is affecting candidate legal practitioners. You will recall that for all these years, the candidate have been examining on 4 papers. Those 4 papers or modules, they were prescribed in terms of the Attorneys Act. So the Legal Practice Act in its regulation 610, describe, as to what modules, there are 15 modules that anybody who wishes to join the profession must be tested on. So a decision has been taken by council that we will no longer continue with the 4-paper legacy exams that were inherited from the law societies and under the now repealed Attorneys Act. And those who have not completed the examination have been given only this year to complete all the 4 papers and outstanding papers. Right? If you don't complete, during these opportunities that will be provided, because there will be 3 opportunities. There were exams now, there will be exams in September, and at the end of the year there's going to be another exams. I think the one at the end of the year is intended to cater for those who are left with 1 or 2 papers. If you don't pass that examination, then next year you'll have to write all 5 papers. And there's not going to be a transfer of credit of all the papers that you passed. You will forfeit those papers which you passed, and you will have to start afresh. So that is what so you will have to start afresh, right? So I want to also take this opportunity to thank all the legal practitioners who are assisting the LPC to realize its goal of facilitating access to justice, because access to justice is a mandate that has been given to the LPC and is not an objective which the LPC can achieve alone. We thank those who continue to accept briefs and instructions to help the needy on a pro bono basis. That is greatly appreciated. And I think, Program Director, I will end there, but I will be available if there be any question. But the point to take home is that the LPC is your LPC. Don't be afraid to knock on our doors. We are available to assist. When you get communication from the LPC, please don't be scared to open that email, because it is through that communication that we will be able to resolve any issues together, because the LPC is not here to punish legal practitioners. As I've indicated, any punishment in the form of suspension or striking is taken as a last resort. And we do have various structures within the LPC, investigation committees, disciplinary committees, and examiners. I encourage, because we are short of practitioners to serve on those committees, anyone who is interested, they can submit their CVs to my office, and we'll add them to the various committees. And you are not getting a salary for doing that work. We understand that it takes much time, but at least you'll get some form of an honorarium, which may not match your hourly rate. So with those words, Program Director, I think I will end there. And should there be any questions on any issues, even outside my presentation, I will be available to answer those questions. And my council member, Mr. Tia, I'm sure he will assist me in terms of addressing, to ensure that all questions that may come about the LPC are. Thank you so much once again for the opportunity. Much appreciated.
One, two. Another round of applause. Thank you, Tisha. Niphinde niqhwabele izandla thina ngathi nibhayazi okanye nifinda uthile ukuba i-principal zenu azikho on the roll, okanye le ndaba ye-exam, which is which one, yeyiphi le ihluphayo. Hayi, kodwa ke mise yona asinangxaki nale exam, sifuna ukufaka thina lo mthetho noba singaziphinda kayi-10 nalena engekho on the roll. Asinangxaki noba singazenza i-6 years i-articles sibe zi-senior candidate attorneys. Ingxaki esinayo yile yoba i-page A1 kwi-admission papers enga-initialwanga yiquery leyo. Yeyona ngxaki leyo esinayo, yeyona ngxaki esinayo leyo. Bendicela uzayi-adressa Mr. Hon uba zijika njani nge-initial ye-page A1, yini madoda. But ke siyabulela kakhulu for the information and the knowledge that you have imparted with us apha namhlanje. Now we have one more speaker that is going to do presentations, and then we are going to open for a round of questions and also clarity and comments. Now, bendizocela, with the same excitement that we're giving all the other speakers, can we please welcome Advocate Mpofu SC. Come on guys, come on.
Thank you, Program Director. Nam Diabulisa Molweni. Isn't that right? Andithethi nani nina abanye abaphendula. But it's fine. No, thank you guys. I'm very, very impressed by the turnout. I think give yourselves a round of applause. And I think we must applaud the organizers, because they told me that last year this was just like a braai, and somebody decided that it should be formalized, and I think it was a great idea. Right, let's start with Justice Petse. Actually, I need my phone there. I'll explain later why I need my phone. Justice Petse, the former Deputy President of the SCA and former Acting President of the SCA and former Chair of the Judicial Service Commission, acting as well. Those of you who watched the interviews for the Chief Justice in the previous round will remember that those were chaired by Justice Petse. We're very proud of him as a product of our province, and particularly this area. Then we go to Nokesi AJ. Mr. Justice Nokesi AJ. Must be very careful here. I'll say something about him as well later in my speech. And then, of course, my blood brother and colleague, Mukaitobi SC, Mnenawa. Matonsela SC in absentia, representatives of the attorneys profession. Here I have to start with Mr. Makangela, because I know where my bread is buttered here. He's my attorney at the moment in one or two matters. And Mr. Sakela, of course, is here. He's our opponent in one of those matters. That's why he gets mentioned second. Mr. Tia has already been mentioned, and I think we must give a special mention to, because this is an event of mainly candidate attorneys and those people who are aspiring to get into the profession. So as a representative of all of those people, let's recognize Mr. Maduna. I'm recognizing Mr. Maduna because I understand, is one of the people who conceptualized this. And in so doing, he approached me last year. I'm sure I'm the first person in this house to be invited to this event, because he asked me last year to commit to this date. A very difficult thing for someone in my position to commit to a date, even more than a week or two beforehand. But I promised him that I would put this date aside. The reason for that is really has already been covered by the previous speakers, which is that as a profession, it is our duty and obligation, those of us who have been here for a short while, to really prepare the ground for those who are coming in, to make sure that those who are going to swell the ranks of the profession going forward and take over from maybe where we have left off, don't have to go through the same hitches as ourselves. So if this was a meeting to address judges or senior counsel, I probably would not have accepted. But once they said it is going to be junior people, candidate attorneys, and even students, then I raise my hand and I say I'm available. Colleagues, I've also been asked to talk about certain difficult legal topics. So I'm going to take my leave from Ngogaito SC. Professor, I'm told is Professor SC. And talk about those topics very briefly, and then talk about what I want to talk about. So those of you, if you ever do a television interview, that's the skill you must always have. You must go there knowing what you are going to talk about. And then whatever the interviewer asks you, you answer the things that you want to talk. So if they say, what is your name? You say, yeah, well, you know, it is this issue of the land in this. But by the way, my name is so-and-so. Yeah. So that's I'm going to do that. But let me touch on the issues that I've been asked to talk about. I thought these issues were very difficult and many. Until this morning, when I was told that, no, on top of these issues, you must also talk about the issues that Madonsela was going to talk about. So I don't intend to cover all those issues because I wouldn't be able to do justice to them anyway. But I've been asked to talk to you about particularly Section 19 of the Constitution, which covers the political rights in the context of the proliferation of cases that involve political party members who want to assert their rights in the courts. And more particularly, this was sparked by the case that Mr. Sakela was an opponent, our opponent on, which was the recent case of the, shall we say, stopping of the ANC Provincial Conference recently. It's quite a topical case here. It's not intended to make one very popular. Yesterday I met up with on my way here, by the way, I met up with the Premier of the Eastern Cape at the airport in Joburg. And we had a few discussions about that matter. Then just when I thought this was over, when I got into the flight, there was Gwede Mandashe, and he also wanted to talk about the same case here. So I'll talk to you about that, but you know, not in a pedagogic way. I'm going to talk about it in the context of what we're discussing here. I've also been asked to talk about Section 18 of the Superior Courts Act. That is that section that determines what happens when you appeal or lodge an application for leave to appeal. What happens to the actual operation or execution of the judgment. I'll talk about that briefly. Then I was also asked to talk about direct access and direct appeal. So these are many topics, and I thought the shortcut in talking about them is to talk about one case, because that case is going to, it will cover all these things I'm asked to talk about, and maybe also this recent Eastern Cape case. But it's also going to cover the broader issues that I want to address with you today. And Tembeka on this about being the source of the law and actually creating in the literal sense of manufacturing and developing legal principles. And I'll talk about how important that is. It's one thing, anybody can read a law book, anybody can come and repeat whatever is in the textbook. But to actually create law and conceptualize new ideas in the profession is something completely different, and it's something that I really want to talk about later. So the case that I want to talk about is the leading case on Section 19, which is why I suspect I was asked to talk about this, is a case called Ramakatsa versus Magashule. This is a case which I argued in the Constitutional Court in 2012, I think, in the run-up to the ANC Mangaung conference. And it has now become the leading case in these cases of political parties. One of the reasons why this is important for you is that, yesterday the election date was mentioned, or rather was announced by the president. If you practice in this area of law, you will realize that literally it's a seasonal thing. Whenever there's going to be elections of the country or elections of the elective conferences of the ANC, these cases jump up and they are all over the show. Tembeka and I have done probably the vast majority of those cases before every conference, and sometimes for both factions of the ANC. I remember one time we did a case, I think it was before the 2017 conference. On the Monday we did a case for the CR17 faction in the Free State, and on our way back we were going to do another one for the NDZ faction of the Northwest in Joburg, yeah. And the guys in the Free State said we mustn't work so hard in the next case. But we said, look, we're still going to work as hard as the other one. So I just want to, this goes to the theme I'm talking about manufacturing and sourcing law and conceptualizing. The people that you have invited here really are relevant to that topic in many ways. Let me explain. The reason why there was a Ramakatsa case in the first place, which has become, as I say, a landmark and a decisive case, is because of cases that we did here in 2011. Ramakatsa was in 2012. So that story starts here in Mthatha. Mr. Nochesi, AJ, when he was still just an attorney, actually called me one day. I was minding my own business in Johannesburg. I think I was a kind of a senior junior advocate then. And said, look, we have to fight these cases. There are these cases about members, was it Matatiele? There are members of the ANC in Matatiele, and they are aggrieved, highly aggrieved by the way they've been treated by the ANC and so on. Now, I was still a member of the ANC then myself. So I said, but you can't take the ANC to court. What are you talking about? And Mr. Nochesi said, well, if they've breached their constitution, then we can take them to court. And indeed we did that. Okay, I think I mustn't get into much detail here. But because I'm remembering that one of the judges before whom we appeared he is still around, yeah. Anyway, that person didn't, I think, understand what we were saying about the constitutional rights, not constitutional in the big C word, just the breach of the constitution of the ANC. Because at that stage, the cases were confined to that question about the breach of the ANC constitution. Anyway, cut a long story short, having cut my teeth in those Nochesi cases, then I was asked to do Ramakatsa. Ramakatsa was it's not surprising that it became such a landmark case. Let me tell you briefly how it came about. So the members of the ANC in the Free State, led by a gentleman called Mpora Makatsa, arrive in my office and they say, look, we want you to do this case. It's about, I can't remember how long, before the Mangaung conference. And we want you to tackle the ANC because it has messed up the entire process in the Free State. So I tell them, as I normally do, that look, okay, well, you must get an attorney, and they say, no, we've got an attorney, Mr. Besaitenode. And they come from Bloemfontein, so you can understand. I've never met Mr. Besaitenode. So I think Mr. Besaitenode was just a post box. Yeah. But the point I want to make is this. These clients were what you call the model clients. They actually, half of the work of that case, they did themselves in the preparatory stage. I had my own ulterior motive. I thought, okay, this case, we have to make it a very important case so that we can avenge Mr. Nyoke's cases because which had not been understood. So, and these clients obviously wanted to make it important for themselves. So it was a coincidence of interest. Now, what I said to them is that, look, we're going to have this case, we're going to prepare like no other case has ever been prepared. If I want something, it must be delivered. You go to your Mr. Besaitenode, but I want this. This is what I want. And I remember we sat down and did, you know, those flow charts of what a case can look like. I can tell you that those clients, if I said to them, look, I think we ended up with something like 2,000 or 3,000 signatures of ANC members across the entire province. Those guys, if I said I wanted that within 3 days or 4 days, they would deliver it. Sometimes they would drive literally from Bloemfontein to my chambers in Joburg twice in a day. I don't know how they did that. But I'm just telling you how committed they were to the case. Anyway, we constructed this case in a way, this was now I'm talking about creating law. So we then said, okay, we need to have a situation where we graduate these cases from the Nyoke cases, which were about the ANC constitution. Now, how do we make this case to be about the ANC constitution, but also about the constitution of the country? In other words, to link the ANC constitution to section 19 of the republic. So that was the one thing. The third thing we thought we should do is also to create a link between the ANC constitution and PAJA. Now, we all know what PAJA is, eh? Okay. So, and just as an aside, that attempt to link those cases to PAJA until now has not been resolved, because the Constitutional Court eventually found in our favor on the other two grounds and said it was therefore unnecessary to decide the PAJA point. And we think that in the Sakela case we might sneak it in and that point here. Well, they've withdrawn. Some of them have withdrawn the appeal. Others have not. We don't know what's exactly going on here. But anyway, so this happens. We go to the Free State and we have this case. Argue, probably, well, at that point, certainly the best papers I'd ever drawn because of all this, and you know, I'm so sure about this case. We go there, the judge reads this thing. I think he thought, no, this thing is just too complicated. And we argued the whole day, And then in the evening, he gave judgment. No, he gave judgment and said, no, the matter is dismissed on none of these beautiful papers, on technical points. Whether it was, I don't know, agency or we should have served every branch, all sorts of excuses to get out of the merits of the case. Now you can imagine how aggrieved I was, having done all this work and wanting to vindicate Mr. Noches. Now, so I did something which I had never done before. Instead of even going back to that judge to ask for leave to appeal, we did a direct appeal, direct access to the Constitutional Court, from one judge right to the Constitutional Court on an urgent basis, because the conference was in 2 weeks' time. That is how confident I was that that judge had messed up the case. So that covers one of your topics, section or Rule 18 of the Constitutional Court rules and direct appeals. It's not something you must try every day. That direct access and direct appeal. Yeah, Justice Spetzer will tell you that it's probably 1 in 200 that you can get away with it. But to get away with direct appeal, direct access, and agency is not something I'm going to try again myself. Well, I have tried it now against Tembeka, but we'll see. That's a story for another day. All right. Cut a long story short, the Concord then agreed to hear us and granted us the judgment and kind of said, look, all those technical points, put them aside and let's deal with the real issues, and they did. And the lesson from that was there were 2 lessons. My opponents were 2 Afrikaner gentlemen who were known as the kings of the Free State bar. Like these were the big hitters, a guy called Wessels, I think, and another one called Snellenbeck. And that's why in litigation you must go for your strength, not the other opponent's strength. So these guys, when we got to Braamfontein, it was the first time they were getting to the Constitutional Court. So they might have been the kings of the Free State, but they had not migrated upward to the old Transvaal. So I remember this guy called Wessels, when he was asked, there's nothing worse in the Constitutional Court than being asked questions by all 11 judges at the same time. While you're talking to this one, another one is talking. And the Wessels SC said to the guys, when he couldn't answer one question from Musameke J then, I think, he said he asked for a postponement. And Musameke told him, look, this is the Constitutional Court, you can't get a postponement. Just answer the question. Anyway, the point I want to make about that is that this was a process of actually trying to create new law in a particular area, which has now become second nature. By the time you guys do cases of that nature, you'll be citing Rambakatsa, this paragraph and that paragraph. But I'm just giving you the background of how something like that gets generated, starting right from this court here, right up to where it is now. Now, that case, okay, coming back to the technicalities, I've spoken about direct appeal and direct access. In that particular case, there was no section 18 point, but I'm going to create it as if there was. There is in the current Eastern Cape case. Now, what does section 18 do? Section 18 does this. it says, Section 18(1) of the Superior Courts Act says that when you appeal a final judgment, the operation and execution of that judgment is automatically suspended, right? So what that means is that the status quo ante that judgment is will prevail. Now, I've had a big fight around that section against Mr. Nochesi. Mr. Makangela gave Mr. Nochesi a hard time around that section in the last few months. Yeah. But the importance of that section can be demonstrated by what is happening now in the ANC case, again, just to link the two things. So what happened in the ANC case? You all saw on TV that the conference was stopped. I think it was on a Thursday. Was it Thursday? It was a 4-day conference. And Mr. Sakela's clients thought that they were smart. So we anticipated this. So as soon as we got the judgment favorable to us, Mr. Sakela's crew, within an hour, 1 hour, they filed an application for leave to appeal. The one that they've now withdrawn. Now, anybody knows why they did that? Anyone? No? I want the candidate attorney to answer this question. Why did they file an application for leave to appeal an hour after the judgment? Okay, let me answer it. Because they wanted to suspend, they wanted the conference to continue. Do you understand? So, because Section 18 suspends the operation of the judgment. So the conference was already happening. So if they, well, that's what they thought. If they put the application, therefore, by the time the appeal is heard, whatever happens might happen, but the conference will continue. Now, unfortunately, they hadn't read the section properly. Because Section 18(2) says that if the judgment is interim in nature, then it doesn't suspend until they go to court in terms of Section 18. So we explained this, and then there was a few gymnastics around it. And they had a press conference where they said, well, now we're continuing, we are registering members. And then we said, okay, now you are in contempt of court, which they were. So there's another case now of contempt of court against them, yeah. But let's put that aside. Tembeka spoke to you about Section 47, where we were opponents, Section 47 of the Constitution. And he correctly said that's another area where he was just modest to say it was me. Both me and him created almost another new area of law which had not been explored before, at least not in the depth to which it was explored. And that was on the question of what happens to a politician who wants to run for office when they have a conviction over their head. Now, I was on the receiving end of this because it was my client who had the conviction and sentence. These days, it's his client, Mr. Malema, who has the, so we'll see what happens. That's how it works. But on a serious note, that the law around the jurisprudence that has been now built around that question is actually the reason why it's so topical, the fact of what's going to happen or not happen to Mr. Malema, because the whole country was able to follow, you know, in great detail those arguments. So we're talking about, and in the case of Tembeka in particular, there are many, many examples of this, of establishing principles or pushing the law to unimaginable proportions. I'll remember one of the cases we did together was the case of about impeachment, was it? Yeah. Now, cases like that, the impeachment case, there was also one about motions of no confidence, UDM case, and many other examples. I can tell you honestly that when we conceptualized those cases and crafted them until they went to the Constitutional Court, probably 80% of our colleagues thought we had lost our marbles completely. And thought, these are clear areas of law. What's wrong with these people? The Constitutional Court won't even listen to them. But because of the craftsmanship and the ability to foresee how a case will end up, those cases have now become, again, people think second nature. Another case regarding Section 19, which Tembeka did, I was not involved in it, is it New Nation? Yes. Now, that's a case that, again, came from all these other cases, but it took the whole issue of Section 19 to another level, because until then, we all thought it was conventional wisdom that the only way you can participate in the political process is through political parties. If you want to be the president or anything, or even go to parliament, at least at the national and provincial level. Until they did that case, which has now established the principle that an independent person can stand for elections. And again, now when people say that an independent person can stand for elections, everyone would say, of course. I mean, that's what are you talking about? What kind of nonsense would it be if I wanted to be the president that I can't do it? But it was not that for almost 30 years, everyone accepted that was not the case. And that's what lawyering is all about. It's about creating new realities, pushing the democracy, the constitutional democracy itself, into corners that probably the drafters of the Constitution never even imagined. So what I'm saying to you, really, the real message is about all these sections that I'm talking about, all the cases. The real message is you should have ambitions to emulate that kind of lawyering, where you can see through a small looking case and create something out of it completely. You know, yesterday, literally yesterday, I was arguing a case of what at face value looks like a maintenance case. A guy, he works in the presidency, and his wife that he got from Canada. That's another story. Wanted to take the kids. They're not even married, but she got the kids, and now he's supposed to pay 50,000 a month or whatever. Don't worry too much about the facts. But when we went to argue this case, the judge, somebody I know, was even shocked to see me in that court. Say, what are you doing here? You know, this is just a maintenance thing about whether the guy should pay 30,000 or 50,000. And we had to spend about half an hour explaining to him that no, this case actually has got nothing to do with maintenance as such. That's important. But the case was about whether the application of the rights of children can be pushed to such a length that you must say that a case that has to do with the best interest of the child is automatically urgent, because that's what he had found in his judgment. And then there was another point, two other points which are not important. And basically, the story I want to give you is that judge yesterday granted us, after 2 hours, no, it was not yesterday, the other day, the day before yesterday, granted us leave to appeal, and specifically said in his judgment that he did not think that there were prospects of success in the conventional sense. But the importance of the issue that was raised is such that it must go upstairs for the SCA or whoever it is. I think he gave us to the full court to reconsider his own pronouncements as to whether the court being an upper guardian means what he thought it means. So what am I saying to you? A case that might be, if you are high and mighty, you might say, why are you taking me to the maintenance court? Do you know who I am? But the reality is that you can turn any case into what you want it to be, and you can use any case to advance many principles. The reality is this: you cannot change society through court cases. You can't. If you did that, as Tembeka was saying, it's like the absurdity of saying you must restore the people's land by doing a case like court cases. That would take 2 million years before the land came back to the people. Similarly, if you wanted to fix all the ills of society through the courts, you'll never be able to, because one issue can take you 10 years by the time it goes through all the appeal processes and counter appeals and all that. Yeah. But what you can do is the cases that do come to your table is to use them to the maximum benefit of society and make sure that they are not just what they seem to be. That's not going to be possible in every single case, of course. Some cases are just about interpreting a contract, But by and large, every case has got potential to change the world, so to speak. Yeah. And that's really my central message to you today. So those of you who are, you are at a very enviable place in the profession. If some of us could wind back the clock, we would now be saying, okay, I'd rather be a candidate attorney than a senior counsel, because the potential to do good and to do justice is just unbelievably wide. So you mustn't constrain your thinking. And I go back to the importance of this gathering. I just like the way that you have conceived it to be, firstly you got us here under false pretenses. Yeah. But we forgive you, because we were told it's a meet and greet. Now meet and greet means we're not going to do anything, we're just going to be greeted and met. But it hasn't turned out that way, yeah. But on a serious note, I think it's important to have these interactions between, people who have been around for some time and those who are coming in, so that whatever happens in between those levels can be bridged, because that's what it's all about. But I also like the fact that you've brought other aspects, the financial life skills. I can tell you that when the presentations were being done by both the gentlemen who spoke about financial planning, I know he said he was addressing the people who are coming into the profession, but you can be sure that the senior counsel were listening even more intently, because we never really went through all those skills about financial planning and how to maximize and so on. And it's true that if you've come here for money, if you come to this profession for money, you are in the wrong profession. But at the same time, we all need money, don't we? And for you to be able to do all these big, wonderful things of changing the world, you need to survive. You need to have a place to live. You need to be able to take your children to school and all that. Yeah. So don't underestimate the importance of this financial planning stuff, because that's if you are every phone call is coming from SARS about your tax, you're not going to have much creative energy to conceptualize constitutional cases. Yeah. So you need the balance. So the event has been very, very well planned to that extent. Now, Tembeka and I were worried when we saw the poster. It says 200 rand to come here. And we both almost did not come. Firstly, because we thought we don't want to get involved in this, with this Madlanga story, you know, you get, they might be asking us, how did you, what role did you play in that? But also, we also thought, I think the real reason was that we were scared that people won't pay and they will be addressing empty chairs. So I think both fears have been suitably allayed. Should I tell them that thing? All right, you see, yabazi abantu abanolwimi ne? Umuntu axelela athi ndixelela kube nguwe. Nawe uxelelo wakho uthi ungayithethi. Senjenjalo ndenza loo nto. So I'm saying one of the joyous occasions, and this links, by the way, to what I've been saying, because people are not stupid. Eh? People know excellence when they see excellence, and they know quality when they see quality. So you must never listen to the noise. Focus and do what you think is right, and do it to the best of your ability. And that's it. Really, you can't do better than that. And I'm saying that because, well, all of you here, we've said Nokesi AJ symbolizes the future of the bench. But you are the first people to know in the whole country that we're going to have another AJ in the Constitutional Court. And that is none other than Mukaitobi SC. Now, and that is with the fact from why did it have to be Pondomise? So we from the 1st of June for 2 terms. Now what that means is that I have to say this diplomatically. There's going to be some significant addition to the jurisprudence. and output of the Constitutional Court. Yeah. But on a more serious note, yeah, I think we should congratulate Tembeka, not just for that individual achievement, which is superlative, because it's very rare that a senior counsel a senior counsel goes to act in the Constitutional Court without even having, firstly, to be appointed at that level. It's rare. But that is just for senior counsel. But when it comes to black senior counsel, it has never happened. It's not even rare. Yeah. And what I'm saying to all of you, the youngsters who are here, is that it can be done. Anybody, all these things I'm talking about, didn't, they just come from hard work and hard work and hard work and application. We didn't, I mean, when people talk to me, they think I came from some multiracial school somewhere or whatever, despite the accent. Or the lack thereof, yeah. But no, we went to rural schools, we went to township schools, like everyone here. And, had to pull yourself through, the culture shock of getting into, at least in my time, what was called a white university. And getting there, and in the first 6 months thinking, if you think you couldn't hear Bodma, then you think you can't even hear anything what these people are saying. But by the time you come out of there, you have a class prize and delict and this and that and the other. It's not something that is that's a miracle. So particularly in the case of Thembeka, he is every one of you here. Yeah, he started down the road at UNITRA, where now they've made him a chancellor. Okay, that's pushing it a bit far, yeah, but there you are. But what I'm saying is that all of you, each one of you is capable of having those achievements, of creating the law. Thank you. Is capable of taking things to an unprecedented level, and maybe in 20 years' time when we attend this event, we will be announcing you as the acting judges of the Constitutional Court. Thank you.
A round of applause. Come on, ezandleni. Ezandleni, 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 ezandleni. We can all just stand and clap hands for all the speakers that came here and give them the respect that they deserve. Thank you, thank you, thank you, thank you, thank you. Now I'm going to open up a round for reflections and clarifications. Any questions? Anyone wants to say anything? In the next 15 minutes, we are going to do that. I'm going to take 2 rounds of hands. Okay, let's hands 1, 2. We want the first one. There's 2 hands. Okay, let's start with the first round of hands. Then obviously I'll have to start here.
Okay. Mine is for a comment. Firstly, to appreciate the gathering. It's at the highest level, I must reach. Advocate Mbofu, maybe Mr. Noches should have told you that I was your opponent in the cases of 2011. And I won all of them. All of them, up to the SCA, I won them. Sorry for that. I was one of the people. Now things have changed. So what happened in 2011 has changed. But I'm not sure, but we are still traveling the road. We need to strategize. We must congratulate Advocate Thembeka Ngcukaitobi for what he has achieved. All of us, I think, is within the appreciation of each and every black child to say something to him. More particularly is from this region, is from Kala, is from Eastern Cape, from Tata. He was studying here, he grew up here. And I like what you have done, that you broke the news here. And it's a strategic way of doing things. Probably I'm one of the people who received the news yesterday first for a good reason why I received those news. And I decided to I can keep a secret. I'm a trusted person. I can die with your secret. Trust me. We congratulate you, Advocate Ngwaitobi. It's bad for me because I have more than 8 cases that I have with him that are going to collapse, that I have to strategize, big cases, inquest, Steve Biko inquest. Now we must find a way on how to deal with those matters, but we need to give a black child a priority when the hand has been pointed to him. We are expecting from you, we are not expecting anything less. We are expecting from you, we are not expecting anything less than the upliftment of the black community through that court. We know that the court, people have been saying that court is not transformed, but we believe that through your presence, there's a lot that is going to change. Let me comment on another thing that was said about the participation of lawyers in voting process. I'm not saying this because I'm a candidate, but it's because I'm a candidate that needs to be elected. But I'm saying this because I find it very difficult how the process of LPC is working. Maybe you are going to comment on this. We are saying we have a unified profession. The purpose of having this act is to unify the profession. But when it comes to voting, we separate. We say advocates vote for advocates, attorneys vote for attorneys. I do not understand what does it mean when you say you are unifying the profession, but you still have those boundaries that you set, even at a stage where you are putting the very first institution that should govern the highest status of the profession, but you are putting a boundary that attorneys must only vote for attorneys, not for advocates. Advocates must only vote for advocates. To me, it doesn't make sense. And maybe you can assist us. That is a comment that I wanted to say on what you were saying. You said a lot, which was very important, but I was interested on that. Maybe you can enlighten us as to why this boundary, why this thing cannot be everyone ever that they want to vote as long as nominated. Thank you.
I think, Chair, I'm the only prosecutor in this room. But nevertheless, we honor the invite. My question, just as a clarity in terms of LPC. LPC, I'm not sure if you look at Lomqembu admission.
If you look at Lomqembu admission, especially prosecutors, you have Section 25 of the NPA Act, where you do not have to be admitted in order for you to practice, especially in the superior courts. And then on the other hand, LPC is saying you need to be admitted in terms of the LPC. Now, I'm not sure whether has that been resolved or not, because some of us are of the view that when you are appearing in court, you're not appearing as Ubrukwe, as Siku, but you are appearing on behalf of the state. Now, why should you then still be allowed to be admitted in terms of the LPC, whereas you do have the delegation from the DP to practice on behalf of the state? If you can just get clarity around that aspect. Secondly, Kuba Kuluwa, Advocate Ngwaitobi and Advocate Mpofu SC. You have Advocate Mpofu, specifically Mkulwa, you have said it's important as legal practitioners for us to treat each and every case, try to maximize it so that we can benefit the society. But Mhlambi, what should we as public servants, especially the NPA, what should be our role in trying to benefit the society? Because you find that some of us, we are so obsessed with win at all cost or stats, if I can put it that way, which might not also benefit the normal Joe, or especially where smaller courts. Mhlambi Tina, because we're in the high courts, we at least the treatment is different. But we always come across cases where we are not supposed to enroll a matter. You're not supposed to oppose a bail, but because of this system that we're currently operating in, which might not be in the benefit of us pushing our legal students. Some colleagues say we should, colleagues on the other hand, attorneys and advocates should be harsher on advocates in the sense that situation on our personal capacity, but that might be harsh. Ideally, we want a situation where all those that belong to the government, whether it's everyone that is under this, that is governed by the Constitution, we should have one mandate. That mandate is to benefit Abantu Bakoti. But now you find that even the standards that are used by the private sector and the public sector are totally different. Because if that was the case, we wouldn't have inquiries such as the Nkabinde inquiries today. So as the advice, what should be our role whilst we are left with few months or years within the public sector, so that we ensure that we maximize on the potential of these entities where Abantu Bakoti are looking for uncedakalo. Nkosi Chair.
Okay, thank you. I don't know if our speakers are taking note of the questions, but I was just thinking of taking the second round of hands so that we know we close it off, so that you don't answer and then you spark a lot of hands. I'm taking the final round of hands. After this one, we have closed the clarifications. 1, 2, 3, 4. Going once, going twice, Zikabile. No more hands after this one. We are meeting and greeting.
Thank you very much, Program Director. Let me also stand the protocol already established. I will come a bit closer from what you are raising. I was hoping that when Mr. Horner was speaking about this thing of examinations, nizawuphakama ngengoma uba asivumelane nala position ye-LPC. But it seems as if anina ngxaki nalanto yoqalela kulo nyaka zayubhala exams. But be that as it may, Comrade Deputy President of NADEL, Mr. Sakela, the position of NADEL on this one is very clear. We're taking LPC to court. We are in disagreement that if you wrote examinations, imagine you pass paper 3, paper 1, and paper 4. You only fail paper 2. And next year you'll be told that go and start afresh everything. We are opposed to that. And in contrary, I am part of that committee, DP. I sit in that committee, but unfortunately, due to what you were saying, I am the loner voice. I sit in that committee with 3 SCs, 2 academics, and an attorney from Weber Wenzel, who does not come in any of those meetings at the LPC. So whatever that I say, unfortunately, I'm alone. And they seem not to understand. AJ Nochiesi knows LPC at times you have to take it to court in order for them to listen to you. But be that as it may, the point I want to also emphasize from the junior legal practitioners who are here, don't follow in the trend of the old practitioners who think practicing law is about buying Louis Vuitton and Gucci, and forget about the importance of us coming together, voting for Comrade Sakela. Because you know what, the limitation would be, if asina muntu okhona phaya, it's a problem to our senior legal practitioners who want to become SCs. And the reality of the matter into yoba xa ku-aplaywa phaa kuza apply isikakhulu abelungu boBowman and Gilfan, Weber Wenzel, Cliff Decker and North Mayor, all the big five. Now abantu bethu thina singabi nazo i-senior legal practitioners kweli cala lethu because azozihoywa phaa ii-applications zazo. That is the problem ke le nto yethu yongavoti ifike sicompromise kwezo zinto. Xa sele ke sifuneka into uba kwenziwe umsebenzi asinamntu ongaphakathi. Ndakhe ndathi ke Jola ndihambe ndingena kwezi offices sithi masivotelwe LPC. Ndifike kule office yalo sisi athi hayi mina novotela LPC noba uyakhohlela ikubhatalisa imali noba wenzani. Ndithi kuyi problem ke ngoku where you are making a mistake into yoba ungafuni uba sibe ne-representative apha kweli cala lethu epha. One of the things Mr. Horner will know, I always say counselling, if awukhange ukwazi uba ne-fidelity fund certificate ngoDecember, ngoJanuary kungena imali ka-RAF yakulo nyaka kupheleyo iza kucharge LPC for practicing without a fidelity fund certificate. Uzaba nayo le fidelity mhlawumbi ngoFebruary iza kucharge LPC if you practice without a fidelity fund certificate. Because the problem is that abantu esihlala nabo ecounselling abayazi noba yenziwa kanjani fidelity fund certificate. They don't know all the challenges because some of them basebenza kwa-Weber Wenzel khona i-department yakwa-accounting ephaya, khona i-department yakwabanibani yakwabanibani. Akufanwa nawe wena mntu uligqwetha wedwa eofisini yakho. So that is the limitation ke yokungafuni uvota because izinto asuzuba namntu as-understandayo i-practice yethu ibihamba kanjani apha emakhaya. Xa ndizoyeka Mhlekazi sithi who are governing courts as the LPC, la NPA la section to be amended because kwayona ithetha nange 3-year qualifications. We don't want that was strict that the courts from LLB now. So la act layer need to be amended ku correct ezaa zinto zindala zipha kuyo. Zindala zanto zipha kuyo. And remember, if you are going to appear as a state advocate in the High Court, you must be admitted as an advocate. Awuyi uba awu admitwanga as an advocate. So there is that requirement in the High Court. So in those words, I want to also thank umrhabulo esiwufumeneyo namhlanje uqala ku Judge Betts. Andazi noba uMr. Noche sebekhe wakuhlebela ikhonto esiyiplanayo ngawe Judge. But ke asuzuyithetha apha yindaba yakwamkhosi. Nawe advocate Ngqukayithobi le 3 months yakho sikunike yona no minister. Uze uqhube kakuhle pha. Ezinto ziqala kum ke DP kaloku ndi left hand man ka minister. Zonke into ze profession naqala sithethe nam sizixoxe sobabini. Sivumelana ke ngokungazi uba siyayivuma nalento le candidate. Bendimxelele kuba nalento ka advocate Dalimpofu siyade simbone actor and asiyithandi kakuhle apha emakhaya. Iyafuna uba siyiconsiderisha siyinadel DP uba sizade siyithini if it needs be akafuna umuntu wethu egoli ngcono azo actor apha emakhaya. Kuba kuthi icream uba kayo cream kubo uyicream kuthi. So kuzafuneka kube bhetele abuye azapha emakhaya. Mr. Noches umrhabulo AJ osinika wona mna ke ngikhona uhlala nawe undithathe through ngezinto umkhulu kakhulu. That is why benena nekhwele xa ungafakwa kwiposter. Kamnandi ke undinazo ifoto zakho akuziphinde kube khona iposter angekho kuyo. Uba awufakwanga kwiposter awuzi kwalapho Jola. So ufuneka bayazi lonto. Mr. Horner, thank you very much for representing us and telling abantu these things. Because the reality of the matter kufunekanga abantu bothuke sesenzeka. Funeka bazazi kwangoku about these things. We are trying to change the posture of the LPC. Ngokuba i-LPC must consult from time to time. Sibhaqile ke pha advocate Ngqukayithobi by LPC kukhona section 95 subsection 4 paragraph A esimvenge candidate attorneys. Ngoba i-LPC ayina right to take decisions without consulting the profession. Unfortunately ke ndicherisha la committee le yakwa finance and HR senyuse fees. So nayo bajikela ke kwi meeting yethu ne-AFT ne-BLA. Nathi for that into niyenzayo pha LPC andazifaka nam kuyo. So from time to time now iphelile lonto. I-LPC is going to consult from time to time with NADEL, with BLA, with AFT, with PABASA, and with other formations like SAULA. But eyona nto ibalulekileyo xa ndihlala phantsi yinto ibalulekile le nto uba xa siorganayizwa, xa sibizwa ezintweni sibe khona, ngoba ukungabikho kwethu i-profession, it's not about ukuhlala eofisini yakho wenza ii-costs zakho wedwa uhambe uye court uwina amatyala ube nemali eninzi, but it's also about uba size apha sizofumana lo mrhabulo besiwufumana apha kujaji, and sizokwazi uba na ethically sibe on the par, singahlali sisenza into ezingacacanga apha kube sihletywa, because kuthiwa singamasela. So kubalulekile ngoku Mr. Notyesu uyibeke kakuhle u-AJ le nto uba apha umuntu olisela akanandawo kule profession, and nathi LPC asizudifenda abantu ababayo pha. Uba ubile funeka uyazi uba uyagoduka, asinalo nje ixesha loba sibe sixoxa into yomntu obileyo imali, andikhathali noba yi-10 rand ke niyayazi uba i-theft noba imali ithathiwe iphinde yathathwa, but the reality of the matter is that ubile. Enkosi.
Enkosi mhlali ngaphambili. Mna ndinguluyanda wakwaThethane kuTsolo. Owami umbuzo okanye eyami i-contribution i-around laa mcimbi womhlaba. Ngokwe-experience yam ndidla ngobona kwi-engagements advocate Ngqaitobi no Judge John Hlophe that i-solution question ikhona apha ku-constitution, but ndinomdla kakhulu kulo mcimbi we-solution. Le debate ndikhumbuza i-argument umkhulwa wam nomnye umalume wam babethanda uba nayo. Umalume wam waye-ANC, umkhulwa wam e-PAC, so they had a lot of debates around the land issue. Umalume ke imember ANC wayenento ethanda umbuza umkhulu wami xa esithi awunothi ukhululekile ungenamhlaba, athi konje mtshanam le nto yenu yoba nibe nisithi nifuna umhlaba sikhululekile nifuna ukwenzani ngomhlaba, nifuna utena, nifuna ukwenza izitena, nizawuthini ngomhlaba? But learning from all these contributions from people like you indifundise mhlawumbi to an extent the level of commitment to the debate land question by the ANC. I've also ran into an article that was written by some, I think Tsebeza at some point, where a lady that was in exile in Zimbabwe between 1987 and 1990 was trying to convince the ANC to have a land redistribution committee before the negotiations, and the ANC was not interested. So again points to the question of I don't know, commitment, and at some point people came out of negotiations saying they were being lectured, especially with land redistribution platforms. So I'm really interested in saying, how do we then? I understand that there's steps that have been like mechanism that has been put forward, including this willing buyer, willing seller, and all that. But I'm interested in saying, how do we then, go forward in relation to the land? Is there a real solution in the constitution? But before ndihlale phansi bendirhalela ukugqitha nje into enethi there's an issue around the concept of every citizen and everyone in the constitution, especially in terms of section 22, section 27, 9, 10. I've been calling the Bengenda Kilega Kuyen and Ogwenza a competition law, but I ran into a case Somali Association of South Africans, where the court said the interpretation that says when you are saying every citizen, you mean only South Africans, is misguided. And I'm very interested in this distinction especially in relation to what is happening in South Africa now in relation to xenophobia and all the things that are happening in relation to economic opportunities, South Africans and immigrants in South Africa. Maybe I understand that this is not, my second question is not part of today's session, but if you have time, or maybe in future, I think this is something that needs to be, considered in the discourse. Thank you.
Greetings everyone. Standing is Kamva Mbangata. I am currently a candidate attorney at Msojana Stag Incorporated Attorneys. I have questions for the speakers for the day, and I will first start with Justice Betts. It's a question I intended on asking him when last year we invited him for a street law event. It's just a simple question that says, what lesson in his decorated career has he learned about the legal profession? That's the simple question. And then to the senior counsels, my question is directed on direct access at the Constitutional Court, and whether is it something they would advise be done on a regular basis, considering the fact that the views of the lower courts matter. So this culture of appealing right away to the Constitutional Court somehow has to be discouraged, so as to promote valid reasoning from High Court, Supreme Court, all the way to the Constitutional Court. And then lastly to Mr. Lastly to Mr. Ona, I think Mr. Tia has covered me insofar as proving that it is an established fact that LPC seems to be viewed as a monster by practitioners. And I want to ask if have they started making arrangements to curb that and to present LPC as more of a body that is in protection of practitioners rather than chasing behind them. Thank you.
Good evening, everyone. My name is Uvuyo Boko. My question is directed to Advocate Nungaitu Senior. I wanted to ask Nduvile uthetha nge-land expropriation, and very personal to me. I wanted to ask whether or not the bill does cover the agricultural sector, because as it stands right now, the agricultural sector is losing a lot of investments. Our fathers, particularly my father, used to work a farm, so I know that this bill has a negative impact on the agricultural sector specifically. So I wanted to ask, Uba Umteto, is it going to protect the farm workers? Because right now they're losing a lot of jobs. Banks are no longer taking loans to cover the agricultural sector because they don't have that land collateral. So I wanted to ask whether or not this bill will really protect the ground workers, the people that are working in Mazambaneni, the fathers that are putting us through education, and whether or not izokwazi ukukavarisha everyone so that it's job security, as much as it wants to cover historical inequalities, which I get, but in terms of food security, are the people in the groundwork going to be protected? Are the jobs going to be safe from this land expropriation without compensation? Because as it seems right now, a lot of farm workers are being let go. We're losing a lot of jobs. Farm workers are coming back home. So I wanted to ask whether or not is there going to be some sort of synchrony or balance between the bill and the farm workers. Are we going to be protected? Our fathers going to be protected by this bill, particularly in the agricultural sector.
That marks the end of the questions, and then I'll hand over to our guests. it's in a willing speaker, willing speaking basis. Anyone can start. Mr.
Thank you so much, Program Director. There were 3 questions directed to me, and I think the first 2 are not easy to answer, but I will do my best to answer them. I would have loved to have senior legal practitioners who served on the National Forum, just to give the, on the question that Mr. Sakela has asked. But as I understand it, we will be aware as to why the Legal Practice Act was introduced. Right, one of the issues to be addressed was transformation and to restructure this legal profession, right? And even when it comes to the nomination and election of council members, nationally and provincially, you will note in the Act, as well as the regulation, that it addresses that issue of representativity in terms of demographics, in particular gender and race. And it does not end there. We also want the structures that are established within the LPC to also reflect that, in an effort to transform the legal profession so that there is a balance. So now to come directly to the question Mr. Sakela has asked, the numbers, of advocates and legal practitioners who are attorneys are not equal, right? So that restriction to say advocates must vote for advocates, attorneys must vote for attorneys, it is intended to ensure that in those structures, everybody is represented and there is a balance. If we were to allow attorneys, for instance, to also vote for advocate, you'll find that, other groups will not have representation, right? Especially if that advocate is known by many or too many attorneys, and that will defeat that objective of transforming the legal profession and restructuring it. I think until the fields are leveled in terms of numbers, maybe that will be the case in the future. Maybe there will be amendments to the legislation, because those requirements for the composition of the council nationally and provincially were determined, in terms of the law by the legislature. So the LPC is the implementer of the provisions of the Act. It doesn't take, decisions. Those requirements are in the Act. The LPC, as an administrative body, it must implement for as long as it has not been changed. However, because the law does not remain static, it changes. At the LPC, we do welcome any proposals for the amendment either to the Act or the rules, and I can assure you that once they are received, they will be considered by the National Council, and if they support, then they will engage the Justice Ministry to have those amendments effected. So for now, for as long as they are still there in the Act, we will implement them. But as I've stated, I think the reason was more to have a representative profession, also within the structures that are established. Because I know even in this committee, which is now going to be established, for the senior status, that requirement was there. except that it didn't specify in terms of gender and race. It just said advocates, attorneys. I hope I have clarified it, Mr. Sakel. And the second question, I think that Mr. Tia covered it. The Legal Practice Act is very clear that any person who wants to be recognized as a lawyer must be admitted by the High Court, and after admission must be registered with the LPC. Regardless of whether he or she is going to practice, because we keep two roles, non-practicing role and the non-practicing role. And the requirements for admission are set out in the Act, Section 24. And whilst experience, of serving as a prosecutor under the Attorneys Act was recognized as one of the bases upon which aspirant legal practitioners can rely on for admission without having undergone a PVT or practical vocational training, that has changed. So that the requirement of the experience is no longer a requirement under the LPA. Everybody must undergo that practical vocational training, be admitted by the court, and be registered. Otherwise, that person cannot be recognized as a legal practitioner and cannot argue cases in courts. I hope I have clarified that. And the last question, about the LPC being viewed as a monster and what steps the LPC is taking or has taken to address that issue. I can assure legal practitioners here that even at the provincial level, provincial council, the chairperson, Mr. Asane Pagade, because I was also part of the Law Society, he always reminds us as official to say, legal practitioners used to call law societies war societies, and he does not want that, with the LPC, right? And we are taking steps, Hence, when I was addressing this gathering, I said the LPC belongs to the members of the profession. It is theirs. They must not be scared, to approach it whenever they need guidance, and we will assist. The problem, which creates this impression that we are after lawyers to punish them, it is because, one of our role or mandate or function, when we receive allegations of misconduct, they are simply allegations, they have not been proven. We must investigate through the independent committees, because it's a self-regulating profession which comprises of practicing legal practitioners. And when that complaint is sent, it is important that it is responded to, because not responding to it doesn't help to resolve the issue. If no response, then the council is left with no option but to take those necessary action against that law. We don't want to do that, because I've stated that without legal practitioners, we cannot speak of the legal profession. And one of our mandates is to facilitate access, to the profession, and to remove any barriers, either artificial, of entry to the profession, right? And I also pointed out that we don't rejoice as council whenever we're to take those drastic measures, because remember, if we take those drastic measures, they can be costly first, and making the cost of regulation expensive, which means that we will have to recover those costs, to regulate the profession depending on the number of complaints as they are increasing from the legal practitioners through increased annual subscriptions, which we don't want to do. So we want practitioners not to ignore communication from the LPC and to respond to it. It could be that response would help resolve, the issues. In the absence of it, the issue will remain unresolved and the council will take a decision based on one version. But whenever, we get an opportunity to be invited in gatherings like this, we do come, and I think this is the last point. I did mention that we do have rules. We are governed by law like any other profession, and those rules and the law are there to be complied with by legal practitioners. We only intervene only when there is non-compliance. And in order to facilitate compliance, where legal practitioners struggle, our doors are open and will assist. Just for an example, the council took a decision that on the point that Mr. Tia mentioned about FFC, that as we see that there are practitioners who have not submitted audit report, they don't have an FFC, but they are engaging with the LPC, in an effort to comply. Then we don't take action against those. We only proceed against those who don't engage with the LPC. Even if we send communication to them, they don't respond. Then action is taken against those. But those who are attempting to rectify non-compliance with the assistance of our offices, we don't proceed with litigation. So we try and assist until they are compliant. I trust Program Director that I've covered all the questions.
Yes, you've covered them. The act is clear, Mr. Rona. Thank you so much.
Program Director, there's one question which was posed to me, and if I understood it correctly, it talks to what I would call the attributes of a good judge. One that readily comes to mind is humility. You have to be humble as a judge. Understand that you are not a superhuman being. Keep an open mind and listen to everyone who appears before you representing a client, if of course they've got sound argument to advance to the court. Impeccable integrity. It cut both ways for judges and legal practitioners. As a judge, as a legal practitioner, hard work, hard work, hard work. There are no miracles. If one day you want to be invited to serve or grace the bench of the Constitutional Court, you have to work hard from day one. I remember a saying by one of the Lord Justices, I'm no longer young, so sometimes memory fails me. But it is to the effect that what this Lord Justice said, I want all my judges to be gentlemen. You'll bear in mind that was more than a century ago. So my conception of being a gentleman, if they know a little bit of law, is all the better. I don't know whether eminent counsel seated to my right will agree with that. I know that Advocate Mbofu did mention earlier on that he advanced argument which he thought, was valid, and that, the odds were heavily stacked against his opponent. But lo and behold, he lost that case. So it is necessary for judges to get to grips with what the issues are, what the argument advanced by the parties, and unfortunately, if there are opponents, this one will say, with respect, my learned friend, arguments doesn't wash. This is what this case says. And sometimes they cite, the same case to support their argument. Then you must be able to determine which of the two arguments, based on the facts and the law, must prevail. So, as legal practitioners, take it as your responsibility that you have to protect at all times the image of the profession. Because if there are people who do things they are not supposed to do, they debase the profession. And to conclude, I just want to say to all of you, candidate attorneys, newly admitted and aspiring legal practitioners, your background doesn't define your destiny. We have perfect examples in our midst this evening. So the ball is in your court. Grab the opportunities that you have. Don't let them slip through your fingers. Thank you.
Thank you so much.
Thank you very much, Judge Betzer and Program Director. Okay, let me go through quickly the questions that were asked to me. The first one was from Mr. Brukwe about the role of civil servants in the legal profession in fulfilling some of the things that I was talking about. Well, it actually doesn't matter where you are placed in the profession for you to do the things I was talking about. Whether you are a prosecutor or a defense counsel, or as I demonstrated, even in any type of case, you have an opportunity to do it. And that is because you have to understand why are we here in the first place? Why do we have this profession? What are we trying to achieve? Why do we have a constitution and all that? Then you'll realize that, like I was saying, a case for that particular client, this is the most important case in their entire lives. For you, it might just be, it's just a small thing about, neighbors fighting about the boundary wall and all that. But for them, it's probably the only time they're ever going to interact with the courts. So, in your case, the problem is more systematic than, of course, as an individual prosecutor, you might want to do this or the other. But I think the system itself is flawed. So, for example, as you're saying, the way you get incentivized as a prosecutor will be some tick box exercise about how many convictions you had. That's, if you pardon me, nonsense. It should not be about that. Of course, you must get convictions, but there should be, and this is something that I practiced when I was once the CEO of the SABC. There should be a way to put some value-laden incentives in your work. So what do I mean by that? So if I was the NDPP, which is never going to happen, I would then change your contract to say, yes, you must get the convictions. But if you're going to bring a groundbreaking case, or you're going to advance a particular broader societal cause, then your bonus, whatever it is, the weighting of your KPAs will be towards that. And just to use the SABC example, what I said to the people who were creating content there was, okay, look, remember you are a public service broadcaster. So if you come to me and you have two productions, and you say this one is going to give us 10 million rand in revenues for advertising, and this one is going to educate old people about how to access their social pensions. As the CEO of the public service broadcaster, I should ask you to flight the second one. The other people at MultiChoice or whatever must go for the other one. In other words, the money, the incentive must be against what it is that you seek to achieve. So those kinds of things which would allow you as a prosecutor equally to participate in the development of society. The next question was about direct access from you, Kamva. Look, it's for counsel. It's difficult. As I was saying, if I'm defending, if I'm on the respondent's side in a case of direct access, obviously I'm going to say the things you are saying. Direct access should never be allowed. The court must be benefited by the wisdom of the lower court, and so on, which is true. And Mr. Ngqaitobi, when he's acting for the other side, will say, well, of course, that is true, but these are exceptional circumstances, and justice would not be served by, in this particular case, waiting for the wisdom of the other courts and so on. So the answer, as always in law, lies somewhere in between. And that is why it's very rare, as I was saying when I was talking about Ramakatsa, that you would get, you just kind of arrive in the Constitutional Court and get entertained. Of course, there are situations where there's no other way. You'll remember one of the cases I did against Mr. Ngqaitobi about the rescission of the Zuma conviction. Now, that case, when we approached the Constitutional Court directly, because I think it was literally the weekend before the incarceration was supposed to happen. So you couldn't argue in that case that, no, we need the wisdom of the SCA and so on. And as it happened, that's actually what happened. I think it was the first time, at least, I don't know if Tembeka has different experience, that we filed the papers, I think, on the Thursday or Friday. On the Saturday, we got directions. It was the first time we had directions on a weekend, yeah. But that was because of the nature of the case. And I think on the Tuesday, we were in court. So there's no answer that can cover all the situations. And it's the wisdom of the drafters of the Constitution that foresaw that there will be circumstances, although this is an apex court, properly defined, but there will be circumstances where you must just arrive there and be heard. Theoretically, you can even go one day to the Constitutional Court without even papers and just say, I'm here and I want a judgment at 3 today. Why? Because the world is going to come to an end at 4 or something like that. All right. Now, the next issue was, oh yes, the question about, as you said, it will be answered in another session. Everyone and every citizen. Yeah, that's a very important question. There are sections of the Constitution, such as the one I was talking about, Section 19, which start with the words every citizen. I think Section 20 and various others. The rest of the Constitution says everyone. Now, if you read those sections, you will see exactly why in each case. So, for example, Section 19 will say every citizen has a right to vote. It can't say everyone, because it would defeat the entire purpose of voting, which has to be done by citizens. But the majority of the sections say everyone, which is what some people criticize, because they argue that the rights in the Constitution should be confined to South Africans, which I think is ridiculous. But there you are. So that distinction, one thing I can say is that it's clearly deliberate, because you find it in one section and not find it in another. So you might criticize it or want to change it, but it was done for a purpose. Right. The last point I want to make is, Sakela was saying to Tembeka that he must give revolutionary judgments. Now, I want to say the reason you forgot to ask for me to remind me why I said I wanted my phone. And I wanted, so I'm glad that I'm going to do this now, after that remark. Because when I was talking about creating law and making waves, I want to give you an example of a revolutionary judgment. This is paragraph 1 of a judgment in the Constitutional Court. It says, the statement by Frantz Fanon. Do you know Frantz Fanon? A real revolutionary. So this is a revolutionary judgment. The statement by Frantz Fanon in his book titled The Wretched of the Earth is, in the context of this case, apt. It neatly sums up what lies at the core of this application. He said, and the judge was quoting Fanon, for a colonized people, the most essential value, because the most concrete, is first and foremost the land. The land which will bring them bread and above all, dignity, unquote. Thus, strip someone of their source of livelihood and you strip them of their dignity too. Now, it's not every day that you're going to get judgments of the Constitutional Court that start like that, until you have somebody who is rooted in what this whole Constitution is all about. And that judgment, that quotation that I have read to you came from a case called Maledu in the Constitutional Court. And the person who penned that judgment was Judge Petse. Yeah.
All right, thank you very much. I think I'll be short. I wanted to mention that I argued Maledu, but anyway, I didn't want to mention it.
You didn't have to say
yeah, I don't have to say it. But, I'm going to answer the land questions, but I should comment on the direct access point. So there is a year, it's a record year, in which every case that Advocate Mbofu and I brought as a direct access to the Constitutional Court succeeded. Every case we brought, it succeeded, both on direct access and on the merits. Right. Started with Nkandla about the compliance with the remedial action of the public protector. Succeeded. Then came secret ballot. Now, Nkandla was brought by the EFF. We were both acting for the EFF as counsel for the EFF. Secret ballot was a strange one. It was brought by the UDM. Dali acted for the UDM. I acted for the EFF. Now, what he says, no, I will cite you as a respondent. When you file your answering affidavit, you'll be supporting me. So we file an answering affidavit, which really is a founding affidavit. We win the case on direct access and on the merits. Then the last case in that same year was impeachment. Impeachment is also brought by EFF, yes. Impeachment was brought by EFF, where he was acting for the UDM. That's EFF 2. Judgment is given on the 27th of December. I was actually on holiday. 27th of December by Judge Jafta, in which they rule in favor of him. Now that was the final stand, the very final stand. There was no room for maneuver. And the man resigned thereafter. Just wanted to make that anecdote that actually there is a record here where every case succeeded. Anyway, those years don't come back anyway. I don't think we will ever achieve it. I think that was it. We will never achieve it again. So if you want to know what are the requirements for direct access, read those 3 cases. It's a trilogy of cases that were ran that year. And I must talk about there's someone who asked something about practicing, etc. The only things I wanted to say, I mean, if anyone is interested in my own advice. So when I argue cases, whether it's motion or trial, it really doesn't matter. There is a sort of a method, right? Okay. So the first thing is to understand the unchangeable facts of a case. Like, what are the pillars of the case that do not move, Whether it's the respondent speaking or the applicant, those facts do not move. They stay the same. So you record them down. Then you'll find there are other cases that shift. I mean, other facts that shift, according to the version or the shade and whatever. If you can win your case on the unchangeable facts, so stick to those, the facts that cannot change. Now, once you've done that, identify the best argument of your opponent on the unchangeable facts. Like, what is the best thing that they can say on it? So, not, because often, what we do as lawyers, we think of their worst argument, and we then prepare against the worst argument. That's unhelpful. So you've got to think about their best argument, in other words, against yourself. What is the best thing they can say on this? Rank them up. And then, what is my answer to that best argument? Then you will know that I'm likely to win the case. If you can't work out what your best argument is on the unchangeable facts of the case, then you're going to lose the case. So it's as simple as that. I mean, this thing is a science. It's not witchcraft. It's a science. So. Now, these are the 2 things I do often in cases. And it really doesn't matter whether I'm dealing with contract, delict, statute, the Constitution, etc. But if you do those, you will find that you can improve your win ratio from, I don't know what your win ratio is at the moment, maybe 30%. You can improve it maybe to 60%, because you've done these basics. So when they work hard, they also mean work smart. Like, just know what you're doing. Just don't. So that's just on case preparation and case analysis. Maybe what we should do is we should actually have a session on this thing about case analysis and then just case presentation. Wenza ntoni napha ecourt into le lapha engqondweni, awuphakami nje uthethe, exactly, so mhlambi ke one of these days makasenzeni lonto leyo nike nisibize nje on a workshop ke sincokole ngezonto ezo, and sometimes thathe ne practical cases. Udali was talking about constructing cases from thin air. The 3 cases, this trilogy was also constructed from thin air. I mean, against Massive opposition. We had like respected senior counsel who said the case could never work. We fought mainly about secret ballot. We didn't fight about Gandla and me and Dad I'm talking. We fought only about secret ballot. And then I was in England. Then I heard he has launched it, secret ballot. I said, okay, well, I'm the respondent. But I'll see you there. I'll see you in court. Until they knew the strategy later, what the strategy was. Anyway, we defeated them. We defeated all of them. Defeated all of them. You know, so. And then you could say, Kwabantu, South Africa, and the year again. Ndiyabulela ke Madiba ngalamazwi. You know, ngomnyaka there was an overthrow in one of these countries. And the leader of the coup was a 28-year-old. You know, so after the overthrow, BBC is there. They give him the microphone and say, well, congratulations, you've overthrown the government. What is going to be your next step? And then he looks at them, he says, I don't know. So that's how I feel now about going to the Constitutional Court. I just don't know. You know, so let me move okay, Yomhlaba. Look, no, it's not my view that we can solve the land question by the Constitution. That's not my view. My view was that we didn't need an amendment to Section 25 in order to effect expropriation, even without compensation. And that's what ultimately happened. They've got a statute, and there's no need for an amendment, and they're implementing the statute. The DA is against it, it's challenging it in court. But that was a limited view. I think it's naive to think you can solve an intractable political problem through such a narrow mechanism called the law. I don't even think they thought that's what was going to happen. Because if you look at the structure of what they restitution, starting from 1913. Now, if you counted all of the instances of dispossession from 1913, everyone who lost a land right from 1913 through the Native Land Act, Group Areas Act, all of those, including, by the way, the Bantustan legislation that created the Transkei and whatever, what they had to do expropriation. Now, count all of them up until 1991 when that act was repealed, right? You get to a number of 6 million people total, 6 million. So if you implemented restitution fully, you would only restitute land rights to 6 million people. Now, they've restituted most of those land rights by payment of compensation, right? And that's like 97% of those claims by payment of compensation. So that means that you still leave out more than 5 million people landless, because what they did, they took 30,000 rands as compensation in lieu of the land that was taken. And what do they do thereafter? They go and stand and join an RDP2, still looking for a house. But the house is in the money. You took the money. Well, I ask, well, what do you want me to do? The money is there. Why should I not take it? You know, so that's why the problem is that the ANC has avoided to take the hard political decisions. So I think that's the problem. They could do a form of redistribution, but again, that's a political decision that has to be taken. They could do all of this thing without paying anything, but they are just not taking the difficult political decisions. You know? So that's my. I don't know what Judge Hlophe thinks about it. I've never heard him express any view on this.
Yeah, yeah. No, Judge Hlophe. Oh, by the way, opportunity. I differed with both Judge Hlophe and Thembeka on this, on what he has just said. It's a debate that he and I have had forever. Yeah, as to whether the amendment is necessary or not. But it will be resolved one day. My argument is simple. All those who say we don't need the amendment to give us land, then let's have it. If it's not going to make any difference, then let's have it, and then we'll see after that if it will make any difference. But yes, you're quite right. Actually, Thembeka's position was not the same. I think Thembeka's position was better than the previous position of Judge Hlophe, because as he explained, it was confined to the issue of compensation. Judge Hlophe previously held that there was no need to amend the because all this can be done surely from political will. Well, that was before when he was still a judge. Yeah. Now that he's a deputy president of a political party, his position is in line with that political party, which is that Section 36 must be scrapped. I mean, Section 25 must be rewritten altogether. And particularly on a very serious note, I think the one thing that maybe I should share this, the ANC is guilty of things that are worse than what Thembeka is just saying. I was part of a meeting, I was in the EFF then, where we had a bilateral meeting with the ANC on this question of Section 25 and why we should collaborate in Parliament in effecting the amendment. And I can tell you now, we agreed on, there were three issues. It was this issue of compensation, and then there was the issue of the custodianship of the land, and the third one was the date issue. The cut-off. Everybody, I mean, the discussions broke down later on. But everyone was agreed on the issue of compensation and even on the issue of the date, because it's the most ridiculous thing, as Thembeka has demonstrated both in his speech and in the answer, to have a cut-off date of 1913. Because 1913 was merely the culmination of the dispossession. It was when this thing called South Africa was formed through the 1910 Act. And it was just codifying the dispossession that had happened since 1652. So you can't call that the cut-off date, because that's basically, writing off centuries. And we were also agreed on the compensation. There was some haggling about whether it should be nil compensation or no compensation. But the real issue that broke those negotiations down was the issue of custodianship. Because the ANC was scared of investors, to put it bluntly. That if we say all the land must be in the custodianship of the state, which will then redistribute it, then they thought the investors are going to run away or whatever. And that's what happened. Okay. But yeah, Hlophe's position has improved. Yeah.
Yeah, it helps. I suppose it's a form of promotion from being a judge to being a deputy president. Yeah. I don't know what you think, Judge Betts. And then the last one around the Expropriation Act and farm workers. The Expropriation Act is irrelevant to anything that has to do with land. It's really irrelevant. I wrote this in my book. I wrote it in the newspaper column. I mentioned it on radio and on television, etc. But somehow the public still thinks that the solution to their landlessness is the Expropriation Act. Now let me explain why it's actually irrelevant. The Act is located in the Department of Public Works. It's not located in the Department of Land Affairs. It gives power to the Minister of Public Works and Infrastructure to expropriate land of the state. You see? Now this is the old function of the Public Works Department. You want to build a road, a school, etc. So it talks about public interest and public purpose, but if you actually look at section 2 and 3, its scope is confined to uses by the state. Right? So I don't know how we're going to get the land from that. Why does that work for us? It doesn't work for us. What they should have done So this is an amendment to the 1975 Act, which was also located in the Public Works Ministry, and they've now introduced the words public interest, but the substance of the legislation is still to assist the state to acquire land for its own purposes. Because I think the language that they use is to fulfill the mandate of the department. And when you look at the mandate of the department, it's state needs. So what we need is not the Expropriation Act. In fact, the Expropriation Act doesn't even talk about how you and I get the land. There's no section there. The last time you find a piece of land there is when it's owned by the state. You know, so it starts off being privately owned and then it ends up in the state, and that's the end of the act. So we still need another law called land registration, which will talk about how the land moves from the state to you and me. We don't have that. So yes, I hear your point about farm workers, but the problem is that we have to accept this. The Expropriation Act is irrelevant to changing the patterns of land ownership in order to give land to black people that were the victims of dispossession. Okay, so fortunately for the government, its publicity around this act has been very effective, because it's made even lawyers to believe that this is a land expropriation when the word land doesn't even appear. You know, it was all about property, but just giving the state more power. Then you have to ask yourself, why on earth does the state need more land? Why do they need more property? Right? It's as if we didn't go through 10 years or these other years of state capture, etc. So we've got more land. What are they going to do with it? When is it going to come to us, etc.? Yes, well, exactly. So it would have been better if they were giving it to the people. Right now, they have, under the redistribution program, if you look at the stats, they have 2.8 million hectares of farmland that they have bought with your taxpayers' money, which they have not distributed. Now, what is going on in that land? Who's using it? Right? It's the friends of the ministers and the friends of the politicians and the family members of the officials. This is the biggest problem we are not dealing with. That 2.8 million hectares, that is, which is the total size of the old Zululand. So yes, you're quite right about saying, okay, well, what about the farm? Now, what we have argued about farm workers is that if you are able to pass a redistribution act, one of its elements must be beneficiary selection. In other words, who is getting the priority of land allocation? And we've said, in accordance with the Freedom Charter, the land shall be shared among those who work it. The people who work the land are the farm workers. So they should be at the top of the beneficiary selection list, not the friends of the politicians. Okay, now I'm going to be a judge, so I shouldn't talk a lot. I'm finished, thank you.
Thank you. I just want to end this on a lighter note by giving you an anecdote that illustrates what Tembeka was saying when they say they think him and I are, I don't know what, enemies of some sort. But it has to do with this land thing. So, and it's just advice on how not to be a bad guest. Yeah. So Tembeka wrote his first book, and he asked me to be the keynote speaker there to introduce the book. And instead of talking about this book, I spent my speech on this issue we're talking about, explaining how wrong he was on the on the issue of compensation. The book launch was at the Constitutional Court. Yeah. Yeah. So needless to say, when he wrote his second book, he did not invite me to speak.
Okay, it's only fitting to give our guests the last round of applause, please. Yeah, we are truly indeed honored. And also, you know what's exciting about what is happening here is that it's not a matter of we can get to where they are. It's a matter of we will get to where they are. And we'll get there with all humility. And we'll speak in places and we'll just mention things like we are passing by. My time as a CEO at SABC, and then it's just something nje ibinje apha ebomini ndakhe ndayi-CEO but ke asikho lapho, and I'm thinking about izinto endizingca ngazo nesisazothetha ngazo apha xa sesikhabe ezitafile uba zincinci kangakanani. But yeah, thank you so much. Now we are going to welcome the executive, the guys that brought us here, and we are truly honored because really last year it was a braai, but now this year I think the level has went high. Come on, Kimi, come on. And I know they faced a lot of criticism. Yes, for creating this concept, and it is benefiting us, the future lawyers and future legal practitioners. And these are the settings that we are supposed to be in, where we are picking each other's minds and where we are learning and we are rubbing shoulders with people that have worked this ground and we really aspire to be with them. Can we please do a big shout and round of applause to the executive as they come up front? Come on, can you please stand on our feet if we can and congratulate these guys. We are here because of them. Willing speaker.
Yeah. Testing. 1, 2. Yeah. I want to believe that a protocol has already been observed here, so I would like to stand on that protocol. Igama lam nguSiyanda Komanisi. Ndingumfana walapha eMazangweni, eMsintsana eMtendane. I will not be long, but today I just want to stand here and appreciate each and every one of you for making time, sit here and engage with us as long as hours silap. But I think we all understand that we are attorneys and amaphetha ngabantu abangaphelelwa into yothetha. That is probably the gist of why we are here. Asikho lapha for food and whatever. We are here to engage, share insights on whatever it is that we've shared insights on. Hosting an event of this magnitude is not easy. Yes, I feel like I'm in board exam. Can't nyani. It's hard. It's hard. It's lots of sleepless nights. Kasilale, kasithini sisebenza samba. Sibe nale event lo hlobo. When we started, saqala sancedwa nguMr Makhangela ku-backyard yakhe last year. Sinentente nje phaa saxhela igusha sasiziphiwa apha ngamagqwetha sihamba sicela. Asinamali ke sinayo sisingxobe sihamba sicela. Ukuze le event ibe yi-success, I'd like to thank all the sponsors. That is Liberty Life, Standard Bank Life Group, Sanlam, kukhona attorneys, but kungatshona imini uba ndinga-mention each and every one of the law firms in Mthatha that has assisted us here. Asinamali sinayo, we are not funded by anything. We are just a group of young attorneys who decided that ngenye imini masivuke sikwazi uba senze sibe ne-session elolu hlobo. Sivuka sihambe every day sihluphe sicela imali kuthiwa le imali yokwenzani le, but we had this thing in mind. It's a success because of you. Ngalo mazwi lawo ayabulela Mazango.
Akho semazangweni apha. Colleagues, andazi noba ndingaqala kaphi. Number one, I must say I'm happy. At least igama lam liyavela kule nto. Every day when I wake up, ndisebenzela igama lam. Thank you so much, colleagues, for coming. Umzangwa honestly has said everything. I want to thank Advocate SC Mpofu SC for bringing me ngesandla wamdonsa. Advocate Thembeka Ncungayithobi SC. Thank you so much, Bo Council Base Johannesburg, for flying down to this event, for seeing or feeling a need to come and address the young attorneys, candidate attorneys of Mthatha. And again, kule gathering, I must that we even have someone. I was to find out that we have someone from NPA, because when we made the invite, said legal practitioners, which wanted to say that this thing, yeah, won't game do all up Mthatha. Everyone must come. I was happy manyan while I was sitting there, hearing that there's someone from NPA. We also received a call from Mr. Ntunzi Mwaka. So we will extend the invite next year, because this event will be there next year. We also noticed that there's also people from legal aid who are here. So at least the invite here to Yambile of legal aid, then they came. Mr. Sakela ge ubengezi. Yesterday, but he was busy. He said he will call me back. Then in the morning today, he called. When I saw his name, I was happy. Then he decided to leave everything. It was something to one when he drove from East London. After hearing about the event, Siplano uyenza kanjani and izobanjani, he drove from East London to Mthatha. And he was breaking the law for sure. Thank you so much, Mr. Sakela. Not just AJ. Siyabulela kakhulu. Uthi ke yena uqala bayimpondo omse before anything else. Siyabulela kakhulu Mr. AJ. Now ndiuxelele late, but after explaining about sizothini apha, now uyabona ba mandingasali kulento, mandize. Sibamemile ke abantu abanye abezanga, but wena uzile. Thank you so much. Mr. Horner, thank you so much for coming. Amagqwetha xa idibene kuye kubaluleke uba someone from LPC must come. But when you indicated back as April about you are coming, which means le nto yamagqwetha uyithatha very serious. And indeed le nto oboyithetha yokuthi you don't want us to fight. I don't think if you wanted us to fight, you would be here. Because you took your time, public holiday today, and you are here. So thank you so much, Mr. Horn. Ukhona ke endithe xa ndimfowunela wathi hayi, I'll just come and show face and leave after a while. He's still here. Okay, waphuma ke, and I thought that he has left because go wathi uba wathi uzawuze bahambe. Justice Pence. Thank you so much nangokuhlala up until sibe silapha si-executive sizoyivala le program, the first session yayo ube ukhona. Thank you so much, which means uthe wathi xa uhlala wabona uba le nto yenzeka apha, it is worth your time. Thank you so much. Njengoba siye satsho ukuba izoba khona na next year, we have decided as the executive uba ngomhla 1 May next year you are also all invited again, 2027. Asinazingxaki next year, asinangxaki sponsors. Sponsors afe bezisho uba hayi sizayikhupha imali. So we are hoping that next year sizohlupha kwamntu, because when we started this program we made it clear that it's not for our own self-enrichment and asifuna ukugaina nto ngale program. So each and every attendant that has contributed to this program, basically requested honestly, not because we wanted to have a change whatsoever. So thank you so much. Ndizawudlulisela komnye ke ngoku okhoyo apho rhalela uthetha. This is their chance to speak their heart. Thank you so much.
Hey, kange nilindele kanjani? But I'm here. A lot has been said by these two gentlemen here, giving a vote of thanks to each and everyone who came. Ndicela nje niziqwabele guys for showing up in this event. When we were doing this, planning this event, says up Mayfair, and we were told here that capacity is 200. The first question was, where are you going to get 200 people to come to the event? So we have been planning with that because I wonder people will show up now. But here you are guys. Here Nilapa, that we appreciate so much. And this meet and greet event, Nati says as cool in a way and get to mingle with people of that level. For instance, to airport namhlanje ndiyolanda nje omnye uSipa. Hey, uthe xa iphuma phala esina bona wezwa futhi wezwa. Afike lathi esi wandijonga. That I'm here to pick you up. So izinto ezo siye sizi-appreciate kakhulu when we are doing this event, that we get to mingle and you get to see people that you normally see on television. Abantu abathathwa as law gurus, if I can use that word. So we appreciate that. Thank you and thank you. Ndingabulela kusephandle. A lot has been said and nabulelo kakhulu. Ngalawo mazwi. Afuna ubetha nje mfama.
Siyabulela kakhulu for everything. As the gentlemen have already said, it wasn't easy. In the process of planning this, kuya kwalimala uMaduna. Saqonda uba hayi noba siyayeka sawubuya. Wabuya ubhuti wethu wagodla isandla sakhe. Wathi we are doing this regardless of everything. Despite the challenges that we faced and the difficulties in getting the sponsors and everything, we managed because the vision was clear that we are here to learn, we are here to meet and greet and be met. So I think even though it was not in the traditional sense, SC we did meet and you were greeted. So thank you very much for everything. Thank you for honoring us. We appreciate it a lot. Until next year.
They leave, masibakwabele. So, cela into eyi-one, don't worry. uMaduna seke nalo igqwetha ngabikho umuntu oze xa kumithwa and greetwa babe bembuza phaa bemfuna umsayina umntana abantu ayongozi yemoto leya please attorneys ubethiwe assault ibhaliwe nakwi medical records assault thank you also